801, a date's already been given, so 28th January, not to be delayed.
Highly obliged.
With your Lordship's permission, may I mention the matter that is coming up tomorrow. This is that racial discrimination PIN, wherein your Lordships last year asked me to file a reply to this latest status report filed with it. I have filed my reply. I'll need just 10 minutes to explain why your Lordship direction is required for the monitoring committee.
That's for tomorrow. Why do you want to argue today?
No, I'm not arguing today. I'm only requesting if some fixed time can be given, not tomorrow also, any day. Just 10 minutes time, because some direction is.
We'll see. If your matter reaches tomorrow, then you can.
Items.
We have 125 matters tomorrow.
That's why I was mentioning.
95 today. I'm hoping that the table won't break.
I leave it to Monday.
Yes.
Your Lordship, I'm seeking permission to mention a matter. A matter was listed before your Lordships for your consideration in criminal appeal. It has been dismissed by your Lordships. Now, what has happened is that a second accused has filed an appeal with respect to the same impugned order. But it is not getting listed because the previous matter, cost title, includes the accused number for whom I appear.
Two real brothers accused. So we are seeking for rest.
How is it that his name was included in the earlier?
It was inadvertently included. We have rectified
I
it.
can't say inadvertently included though.
No, the only SLP has been filed by the.
Whatever it is, take it up with the registry.
Your Lordships have already.
You're not going to now start doing the work in the registry also.
Your Lordships, the only.
We have enough matters today. Please don't make a mention. Whatever it is you wish to say to the registry.
Rectification before your Lordship.
While you are IA, whatever it is, where is the question?
It is
Rectifying it on
already,
the oral mention.
already dismissed, my lord.
Well, where is the question then?
Your
On an
Lordship,
oral mention, you want us to change the cost title?
We are
The
pursuing
limit
registry
there's a
since
limit
last
to
4
it.
months.
Sorry, pursue it with the registry. You don't.
Please, ma'am.
My lord, against the same impugned order, my lord already issued notice.
Which one is this?
Status quo. Yes, my lord.
The first item.
This is the first time, my lord.
Issue notice and tag with SLPC number 3042.
And same order, status quo order.
2023. It's
Yes,
there in that.
it is already there. It is.
There in
Your
that-
Lordship,
That's
Your Lordship,
right.
I am accepting. Your Lordship, I am accepting notice on behalf of respondent number 129.
Note his name.
I am deeply obliged.
Obliged.
This wakalat, both the wakalats are also not the same.
Yeah,
It's
that's
not even a
exactly-
question of interpolation.
I'm not at all
We
saying.
don't say anything about taking action against the advocate who is supposed to have. Why would he be interested in altering? And on top of that, you say that you sign blank papers and give it. This kind of practice, if we start validating it by recognizing it, bad enough that it happens.
I understand.
And now you put it on paper that you give blank signed papers to the advocate and you want us to take.
He had said,
No question.
because I understand, but the only
Then the
problem is
Maulik
now.
Kumar Prasad, not in this matter.
Because I understand. The
The
only problem is that they are
Miscellaneous
feeling.
applications, these miscellaneous applications are utterly misconceived and we find no grounds whatsoever to interfere, to recall the earlier order and restore the special leave petition. The miscellaneous applications are accordingly dismissed.
The only thing is that the litigants feel that he had not done anything which has.
I have also compared the wakalats, the
Yes.
two wakalats, the
Yes.
copy which they filed
Yes.
and now what you filed.
Yes.
And there's no question of interpolation because these are two separate wakalats. There wasn't enough gap there
Yes.
for any name to be interpolated.
What had happened?
So you obviously signed not only blank sheets, you also signed multiple wakalats.
That way,
Whatever it is, take it up with your advocate, sue him,
Milot,
and get your money out of the.
it's not about money, Milot.
Whatever it is.
He's feeling as if something is coming from your lordship which he has not done.
We'll have to go by what is stated.
I understand.
Sorry.
Deeply obliged.
Item number 3, I'm requesting for a passover.
No passovers today, please. We have 95 matters.
Mr.
Passover is sought, however,
Manoj,
it is not possible to accept the request. List on.
may I request if it can be tomorrow or day after tomorrow?
No, we have too many matters. I'm not going to make the same mistake that I did. For some reason, I was fixated on 19th of January and I've been giving the same date in all matters. You can see the number of matters.
I'm not
Since
requesting
October.
if it
So literally a classic case of biting off more than I can chew. And unfortunately visiting it upon my brother also.
if it can be
No, I'm not going to
Thursday.
make the same mistake.
Thursday.
No. Now, once you ask for a Passover, you go to the 27th February.
Manoj,
Sorry, we don't have a date before that. in any event, you need to amend the cost title. These three are respondents 1 to 3 are still minors.
Manoj, they are the defendants, Manoj.
They are minors still,
Manoj, they
and
are
you
still
show them
minors.
and you show them as represented by their deceased father.
That is what happened, Manoj, in the High Court also, and they are
Then
still.
you need to take steps. A minor can't be represented by a dead father.
No, that's right, Manoj.
Well,
That's right.
do take steps in that regard also.
Manoj, I'll check whether they are still minor or major also, Manoj. That I'll check.
If they are not minors, you still need to file an application for getting them declared as majors. That also has not been done. Well,
I'll do that.
yes.
Manoj, the office report mentions there is actually another matter, the Ghaziabad development.
SLPC number 11107. But do you, whatever charges you have imposed upon them, do they come within this section 15
Manoj,
2A of the UP
there
urban
are
planning and
SP,
development?
Manoj, there are zoning regulations which specifically mention this, which are not.
Justice Shah's judgment doesn't apply to
Manoj, the zoning regulations have not been considered there, and that is why your lordships have issued notice in Ghaziabad Development Authority.
No, but it is identical. Isn't it?
Manoj, the zoning regulations have not been considered by this
Very well.
court.
Issue notice and tagged with SLPC number 11107 of 2024. Now you have to refund.
Yes, so Manoj,
Refund the
I'm
charge.
stay on that, Manoj. and
Operation of the impugned judgment shall remain stayed till next year.
I'm grateful.
Item 5. How many such people are there? We have one in item 5 and maybe 4, 5 in
5.1.
5.1.
Yes.
That earlier order,
Earlier order is, my lord, this is at page.
3rd December order, which the learned judge passed,
uh,
permitting all untainted, unselected candidates
Yes.
also to
Yes.
appear.
Yeah.
That order you did not challenge before us.
Yes, this is the order I am.
No, 3rd December.
No.
3rd
No,
December order.
that matter, your lordships have passed an interim order. That's it. And you come to page 281.
281.
It's a detailed order.
Start. And here the elephant.
281 বার করো কি বলছে?
Now, because that interim order is still standing, obviously the learned judge feels that the person should be permitted to appear for the interview.
No, thereafter this order was passed, this interim order was passed. That your lordships have passed this order on 18 December 2025.
Yeah.
Earlier. Now that this order has been passed on 12 December 2025. Before that.
Well, you'll have to take it up with the learned judge says place it in a sealed cover.
Yes.
No, this is the kind
They're
of
not going to
Madam,
step in
kind
each
excuse me.
stage.
my lord,
You
excuse
will
me.
have to address
Just kindly excuse me.
for the single judge.
Then we have to give it to the all the 2.6
How
lakhs.
many people are there?
2.6
Is the first
lakhs.
question. No. Why would
No,
it be
no.
2.6 lakhs?
Petitioners.
How many
No.
persons filed writ petitions on par with that Subish, whatever, that 3rd December order?
Subish, this is the.
That 3rd December interim order, how many cases was that similar order passed?
3rd December, after that, this order, this is the one petition. In another one matter, the other petitions are there.
3rd
And will
December.
concluded.
But only few,
Interview
not large
has been
number.
concluded. Interview.
You're not telling us how many people who would be similarly situated to Zakir Hussain
Muller,
there.
3 or 4 or 5 persons are there.
That's all. Then what?
14 persons are there.
No.
Even 14 persons.
But an interview has been.
You're not required
But
to
an
give them
interview has-
appointment.
But an interview has been concluded.
My lord will not
Well,
interfere in this matter. The best of
Cover and
respect.
show it to the
No,
judge.
my lord, interview has been concluded. We have not taken his interview. We have not taken his interview.
When was the interview?
The interview has been finished long back. Only 8 January, my lord, last interview has been taken place.
8th January of this year.
Yes, tomorrow, day after tomorrow or day after tomorrow, we are going to publish the results.
This order was passed on 12th December. Why did you not comply with it?
We have filed on 18 December this matter.
Well, it didn't come up till now.
My lord, this matter has been filed on 18 December.
19th December.
Before this
They
court.
are repeatedly not avoiding the High Court.
Complied with the order
Well,
without
yes.
prejudice.
My lord, 18 December, we have filed it.
Wait a minute.
Mr. Bhattacharya,
Yes, my lord.
on 18 December, when we passed that order,
Ah,
we also directed the 3rd December interim order to be placed in abeyance.
yes,
Therefore, no benefit can flow from it till the High Court hears the matter finally.
that's our point. The High Court has fixed the matter. They did not appear.
But in
They
the
say,
meanwhile, the High Court is acting upon that interim order.
no. The High Court has,
The impugned order refers to the 3rd December order, which it
Yes.
could not have done because we've already kept it in abeyance.
yes, Lordship not kept.
Before the
Very well.
order,
This was on
before
18
our order, it is not.
12th
That is-
December at
yes.
that point of time.
It's not.
But in the meanwhile, the 3rd December order has gone into abeyance, so obviously they cannot.
But the difficulty is now, if the now ultimately in the petitioner succeeds, there will be much more difficulty. Therefore, the learned judge felt it should be,
If the High Court decides in your favor, you can always be interviewed at that point of time.
well, that will create much more difficulty for them.
No,
But
no.
the
Why-
other
why
part
will
is
it
concerned,
be-
well, the other part is
Begin with-
concerned, which is very
Begin
serious.
with Mr. Bhattacharya,
Yes.
because I've been in the bench which passed.
I know, your lordship was there. I had to
Baisakhi
argue the matter.
Bhattacharya,
I know.
I'm there. Baisakhi Bhattacharya, what is it?
Yeah,
What is it?
Vaishaki Bhattacharya, that's the principal case.
Now, in that judgment, it was never our intention to open the doors for untainted, unselected candidates.
No, the untainted,
Mr.
my lord,
Mr. Rahim, in
untainted,
fact, had said that we approached the High Court and we are not
We-
getting any relief.
waiting,
That was how it was.
the waiting list
Not
candidates are
planning on
also
opening
untainted.
the doors for all persons who were not untainted.
But my lord, the
To
judgment
again have a
itself,
second go. That
my
would
lord,
be
judgment
completely
is very clear, my lord, that it is
Sorry,
only
we never
applicable.
said that. We never
Well,
said that
well,
untainted,
if-
unselected candidates.
That
should also
if
be
situation
selected.
arises, my lord, we can satisfy your lordship,
Very
but we are
well,
not on
sir.
that.
File your
No,
counter. We
at-
will stay this order.
Yes, sir.
This order
No,
needs. to be
My lord will
stayed.
kindly, my lord kindly stay, my lord, their portion where, my lord, the interview has to be taken, my lord, videographed. My lord, they are
No,
really
no.
manipulating. Again, they are
Videography
manipulating.
aside, no interviews also at this stage.
But therefore, no interview, but the my lord,
The
interview,
Direction of the High Court, we did the impugned interim order dated 12/12/2025, requiring the appellant, the petitioner commission to interview the candidates who were supposedly untainted but had not been selected in the 2016 selection by granting them age relaxation shall remain stayed in
Yes,
view
yes.
of the order dated 18/12/2025 passed by this court in
SLP number
page 241
281.
to 81.
my lord, this stay is only in respect of age relaxation.
In
Not the next one.
SLP number 35895 of 2025.
Where is confined to age relaxation only.
35895. No, it's a sentence. I've lost this. In view of the fact that
5.1 answer, sir. 5.1 next one.
Not selected in the 2016 selection by granting them age relaxation shall remain in view of the order dated so and so passed by this court in so and so.
keeping the earlier interim order dated 3/12/2025 passed by the High Court in abeyance.
But the lordship also direct, my lord, the authority to appear before the High Court and file their affidavit. They are avoiding the court.
Whatever you wish.
We
to
are-
do there.
They are avoiding the court. No, this should not be encouraged.
What we are saying, we are fine. 5.1 also similar.
Minor, one thing, may I indicate, because of that, 11-12 interview is completed, but 9-10 interview is not yet completed. And another aspect in 5.1,
But
kindly see
this
understanding
understanding of Baisakhi Bhattacharya.
I am not on that, I am not on that.
No.
Kindly see
No
5.1
interviews at this stage.
in
My
camera.
lord, very well, my lord,
No
this is,
interviews
this-
of these
no,
candidates
I am not on
by
that.
this stage.
Kindly see, I am not on that, my lord. There is a direction in this order, my lord. Kindly see, 5.1 order, para 12, my lord. Kindly see, para 12. There is a specific direction because in pursuance of Supreme Court order, the interview ought to take it in camera, my lord. that order is
We've
given.
never said that.
Yes, yes, not, but this is Ajay, my.
We've
Well,
played the interviews now.
Kindly see
Which
the
are already
order,
over.
kindly see the order for once,
Please understand, we are not permitting interviews for them to be videographed now.
not for us, my lord. Kindly see
Whoever it is, no videography at this.
my lord, para 12, my lord. Kindly see
Next
para
matter.
12, my lord.
Next matter. File
Kindly
your
see.
counter.
Fiddo,
If you're
Shukar.
appearing, file your counter. No
There should be
more
some
arguments.
order to all this.
It is confined only to the age relaxation, nothing beyond that.
Yes.
Can we have 2 weeks for counter?
File your counter. Usual order.
My lord,
2 weeks,
List on,
list up to 4 weeks.
list on 10th March. Item 6, issue notice and tag delay condone. Issue notice and tag with civil appeal number 14783 of 2020.
There's also
my lord,
notice on the,
just
what is this
my
council?
Your
Yeah,
matter is over,
Next
counsel.
matter.
Hirabhai,
Your matter
my lord,
is
this is
over.
Supreme Court dictum, my lord. Kindly see Supreme Court
Well, it
dictum.
can't be applied across the board to
Yes, but that is
interviews
the
which are
dictum of
already
the Supreme
concluded.
Court. But kindly see.
Council, is this how the West Bengal High Court
No,
carries
my
out?
lord, kindly see
I'm
para 14,
surprised.
para 14, my lord,
There
kindly
will be some limit
The
which-
matter is over, counsel. Please understand.
grateful, my lord. But this is all for the end.
Anxiety should not expend.
Malad,
You are stepping into the shoes of your client.
My lord,
You are
that
first
is
and
not for
foremost
my-
an officer of
Let
this
us
court.
respect, my lord.
Please maintain the discipline and decorum of
As
this
I'll
court.
go down, my lord,
Well,
but
you are not doing it.
I'm sorry, one request on item 6, there's notice on interim stay also in the main
Very
matter.
well. Issue notice on.
Because there are many orders that are being passed.
Especially petition as well as the prayer for interim relief
Obliged.
and tag with civil appeal.
Item 7.
Delay condoned, issue notice and tagged with SLP criminal number 11588 of 2025.
My lords, there is an interim prayer.
In that, is there any interim order? Next matter.
Item 8.
Please, no, this is,
Please come to page 146.
Yes, ma'am.
You went before the Dubai court.
Yes, ma'am.
You've now got enhancement of the maintenance.
What you
And
mentioned.
page 146, last sentence.
Yes, ma'am.
The plaintiff and the child are not entitled to any support from the defendant for any subsequent period in India after the date 2010-2022.
Please,
There's no question of you coming here and asking for further enhancement in India also.
He's not paying laws.
Even if he's not paying, you chosen to go before the Dubai court.
Kindly see. Kindly.
We find no,
kindly.
we find no good ground and reason to interfere with the impugned judgment.
Laws, they are left in lurch laws.
The special leave petition if accordingly dismissed. If you try to pursue too many remedies at the same time, you end up with no remedy at all.
Laws may kindly see.
Well, you've gone to the Dubai court has said this.
No,
After
because-
22, you're not entitled to claim maintenance in India.
Please, ma'am.
There ends the matter.
He was not paying.
You went to the Dubai court, therefore you invited this order, you're bound by it. No question. Next matter. Item 9, have you found him?
Could not find
Then we'll dismiss it on that.
let there be.
Despite ample opportunity having been granted, the Union of India is unable to locate the respondent for effecting service of notice. In such circumstances, we cannot examine the grievance of the Union of India with regard to grant of bail to the respondent. The special leave petition is accordingly dismissed.
The trial court can still issue non-bailable warrant for them to do. Because
How
it's
will
not attended.
non-bailable warrant,
Yes.
who is to execute it? Your police machinery.
That's true.
You're not able to find him.
But then, my lord.
Then what is it that the non-bailable warrant will achieve? Only dates before the trial court. They have enough matters on their docket. There's no need to burden it further.
This matter may be sent to the mediation, my lord. There is a possibility of the settlement.
You're for
I am for the respondent number 2.
Your Lordship, I make your lordship.
very mediation of it. If you're before the mediator on 19th February. Both are here?
Lordship.
The state is
Where are
not
they?
here.
Where are they?
Your
I am for the complainant.
Very well, we'll give you an earlier date, 3rd February.
much obliged.
Here now the
Item 11.
Earlier interim order in that matter.
No, my lord,
Interim
that's
order
the wrong
dated
statement.
15/5/25 shall stand extended till the next.
My lords, on the last
11.
date, there was a wrong statement made by the state that it is at the stage of cross-examination. The matter is still at the stage of examination in chief, my lord.
And I've spoken to the public prosecutor in the trial court. He says he'll take 5 to 6 dates more, my lord. I've been asking for adjournments time and again, my lord. It's been 3 months.
No, but the complainant has not been examined.
Not yet. It's still at the stage of examination in chief, my lord.
He's in the witness box. He's examined.
Why is it continuing for so long?
I really don't know why should it take such
My
a
lords,
long.
the public prosecutor says he will take 5 more dates, my lords. And every time the matter gets listed after 15 days, my lords. They call him at 3:30 and they close it at 3:45, my lords.
What is this?
My lords, on every date.
We are informed that the examination of the complainant is still ongoing before the trial court. We request the trial court to give priority to this matter and conclude the examination of the complainant at a stretch by taking up the matter on a daily basis to the extent possible. List on 20th February.
Lord.
Great.
Item 12.
I am for the petitioner.
You've received a copy of the counter. No passovers today. Have you received a copy of the second counter, 16 January?
Yes, day before.
There,
Yes,
say
Lord,
that
day
you are
before
not
yesterday I have
cooperating,
received.
you
Lord,
will
I'll
not come on.
I'll file rejoinder to their counter. Lord, there is much more which they have
Specifically
not
say that
brought
you
into my
failed
Lord's
to
notice.
appear on the date which you were asked to come on.
Lord, I have specific instructions. Lord, I went there. Lord, I even called the investigating officer 4 times. Lord, but he didn't pick my call. Lord, each and every. Lord, I am still ready to go. Lord, may fix any date. Lord, I'll again appear before the investigating officer.
In the light of the counter affidavit dated 16/1/2026, filed by the state, asserting that the petitioner failed to appear on 25/10/2025 to cooperate in the course of the investigation. We direct that the petitioner shall appear before the investigating officer on 3rd February, 2nd February at 11 a.m. The investigating officer shall make himself available on the said day for that purpose. Now, don't say that he's going out of.
Lord, there is an interim order. Lord, that may be continued.
Meanwhile, the petitioner is at liberty to file his rejoinder to the counter dated
Lord,
16.
interim to continue, Lord.
Earlier interim order dated 25/8/2025 shall continue to operate till the next hearing. List on 20th February.
I am deeply obliged.
R8 is not served.
Yes,
R8, someone is appearing?
It was served.
R8 is not served. That is the office report. All other states you have shown as represented by the chief secretary. R8 is the state of Uttar Pradesh and you don't show that. So who will it go to?
I have an email from the email has sent me that there.
Well, we'll go by the office report, which is dated 17th January.
Then I'll take.
And it says that R8 is not served. And I've looked at the cost title and you show R8 as not being represented by anybody. A state has to be represented, is it not? Who will it go to then? Obviously, it can't be served.
There is a.
Office report dated 7/1/2020.
There's an interim application.
Reflects that. Without, once notice has been ordered, it means that we wish to hear the other side before we take up your plea for interim relief. 17/1/2026 reflects that response number 8 has not been served. And counsel for the petitioner shall take necessary steps in that regard.
One small. Your Lordship, I am appearing on behalf of CB, respondent number 2. We will be filing our.
The served respondents are at liberty to file their counter affidavits within 2 weeks. Rejoinders by order. List on 27th.
Lordship, can I mark my appearance?
Please do.
Item 14.
Lord, look, see the last order sheet, Lord.
Yes.
This is that same case.
R3 has now filed a counter.
Yes, and what is happening is, Lord, after they lost in DRT, they go for FIR. Now, who goes for FIR? Not the bank. Auction purchaser. And in the DRT court, they've lost the case. For
Mr.
6 years, they
Tanka,
never denied those documents.
Mr. Tanka, we'll have to give you another date. This requires to be heard. and
But
today may not be-
what I'm requesting, he's in jail for more than a year.
Yes,
And-
19 December you went.
Yes,
But today is not the Mahurat for you.
very well. I'll leave it to that. But could it be a short date, Milord, if possible? Because his wife, he's living with only his wife is there who's a cancer survivor. Nobody else in the family.
These are
Very
30th January.
good. Should we give a short note, Milord, with pages? With
Sure.
it, Milord? Because
The counsel for the parties are at liberty. 13 others. But why is your list showing me less number of matters?
Actually, advance list has come.
No, but
20 January.
update it. Fifteen. Done, counsel for the parties are at liberty to file brief written submission. That's 30th January.
30th. Grateful.
May I please, Your Lordship? Your Lordship, in this, she is cooperating with the police, but the police is giving her great torture. She's giving electric shock during investigation, everything, Your Lordship.
According to the counter, she's admitted everything and
She, because of the electric shock, they're making her write everything. They're just supposed to sign this
19 of the
signature.
counter, Milord.
And she's already paralyzed, she was not well, Your Lordship.
Kindly see,
file a rejoinder. Without your filing a rejoinder, we can't take these kind of submissions. And counsel for the petitioner seeks time to file a rejoinder. The counter affidavit filed by the state list on 27th.
Lordship, give me some time.
27th February.
Deeply obliged.
She should continue to cooperate.
Interim order dated 9/10/2025 shall continue to operate till the next hearing. No third degree methods, please. When we are seized of the matter, you're still feeling free to.
Not for a lady.
Let us not be blind to the realities of what happens in this country. So please advise them, when we are seized of the matter, not to use their usual tactics.
No, even otherwise, no.
Otherwise, you say that no third degree methods are adopted by the police in this country. We'll hold you to that if you make such a statement.
I have different experiences. Whether it can be third degree in what sense, Milord?
I see. So their degree is within the third degree, according to you. Very good.
Lot.
Counter file.
Miss Anisha Rastogi appears for the state virtue.
Who's for the petitioner? Item 16.
What is online?
Online? Council in item 16. Where is he?
Problem is there.
Problem is there.
My lords, he's not unmuted, my lord.
Yes. You have to unmute yourself at your end also, not just the officer here. Yes. Do you need to file a rejoinder to this counter? It was filed yesterday. Council, can you hear me? We find the learned counsel for the petitioner is unable to address arguments due to online due to a glitch.
And somebody else is NK Majumdar.
Unmute him.
Mr. Majumdar. He's muted on his side. Mr. Majumdar, you will have to unmute yourself. Anyway, we'll give you time to file a rejoinder. Please do it by the next date. Unable to address arguments due to a glitch on his side. Time is granted for filing a rejoinder to the counter affidavit filed by the state. It shall be done by the next date. Keep it as short as possible. Too many orders, no? The rejoinder may be filed. Don't write all this also. Just say counter of the state, counter filed by the state, rejoinder, if any, may be filed by the next date of hearing. Interim protection granted on 26/9/25 shall continue to operate till the next hearing. List on 13th March.
Needs a battery.
Item 17.
May please your Lord,
Joint investigation.
The joint investigation and statement was recorded on 11th.
So there's no need for custodial interrogation.
There is the documents which are fabricated,
These are all
which have been
fabricated.
sent.
You
and the
don't
forensic-
expect him to sign a confession, do you? Then
Though the forensic report is awaited.
the leave grant, the appellant is. Well, today, not a day for final orders, so we'll extend it and counter file. If you need to file a rejoinder, file it. Otherwise, rejoinder, if any, may be filed by the next date of hearing. Earlier interim order dated 8/10/2025 shall continue to operate till the next hearing. List on 9th, 10th March.
Item 18.
R2 is not served.
Police report. What sort of a bail?
In the morning.
R2 is not served. Without R2 being served, then
I'm appearing for the R2, Your Honor.
you're appealing.
Yes, sir.
You need to file a counter.
Yes, Your
It's
Honor.
against.
We have filed ours, it's not on record yet. It's next. We have filed ours.
You filed a counter?
It's not on record.
served it in the
We
morning.
will serve this
Very
morning, so it will come on record.
What is your name, counsel?
Bhuvnesh Mittal.
Bhuvnesh Mittal, and counsel states that he's instructed to appear for respond number 2 in these matters. He's permitted to file his wakalat well before the next date of hearing, along with his counter affidavit. Learned counsel appearing for the state of Uttar Pradesh says that the counter affidavit was filed today morning. The registry is direct to verify.
Your Honor, the
Put up the
copy is
same.
also required to be.
Replies, rejoinder, if any, may be filed to both the counters before the next date of hearing, list on 13th March.
Which may extend the interim orders.
Earlier interim order dated 8/10/2025 shall continue to operate till the next year. Good.
Item 19.
Item 19, I filed my Vakalat on Saturday now. Some time for filing
Filing.
something. I filed it for R1.
R1 is it?
Yes, sir.
You filed your wakalat also?
Please, on Saturday,
And counsel for respond number 1. Your name is not shown though, only counsel for.
It's on record in the portal, not on the listing. Saturday.
And counsel for response
Mr.
number
Answer
1
Jain has filed the Vakalat.
takes time to file a counter after usual order. Earlier interim order dated 3/12/2025 shall continue to operate till the next hearing. List on 23rd March.
Deep reply.
Item 20.
20
Time
no
to file
counter.
counter.
Learned counsel appearing for the state within brackets NCT of Delhi takes time to file a counter affidavit. Usual order. List on 27th February.
Lord. Obliged.
Item 21.
Your Lordship, I appeal for respond number 2 and 3, Your Lordship. I filed the counter on Saturday. Your
You filed it.
Filed the-
What about R1?
I am appealing for R.
No counter?
No, I will file it. Your Lordship, last time,
You're on caveat also.
ah,
And you didn't file a counter.
because last time in matter appear, your Lordship said that your counter is not necessary.
I
Government,
mean, we say your counter is not necessary.
your Lordship
It is
wants
not
to know
for
the
us to
stand of
decide
government.
whether, it is not for us to decide whether you should be filing a
I
counter.
will file it.
You're a respondent in the case. It's your call whether you wish to file a counter or not.
I will file it.
Learned counsel for respond number 2 and 3.
Yeah, filed on Saturday.
2 and 3 states that the counter affidavit was filed on Saturday's date, 17th. Registry is directed to verify and put up the same. Learned counsel for respond number 1 seeks some more time to do. To file his counter affidavit, rejoin the if any, may be filed well before the next date of hearing, list on 20th March.
Item 22. Your Lordship, Mr. Sridharan is appearing through VC.
Yes, differential duty has been paid.
No, according to the office report, they have not filed proof of. There was some amount.
Your Lordship, it has been paid.
But no proof file?
Your Lordship, we have a receiving letter.
You can't keep it with you. You need to file it, is it?
Yes, Your Lordship.
Anyhow, this matter perhaps requires a hearing.
We have filed our counter.
Counter is filed. Any need for a rejoinder?
Your Lordship, actually, there is a writ pending before the High Court.
Question is, do you wish to file a rejoinder?
We will find it.
When counsel for the petitioner seeks some time to file a rejoinder to the counter affidavit file. Proof of payment of the differential duty shall also be filed along with the said rejoinder. List on, we'll take it up on Wednesday. March.
I think they're looking for a slightly longer date because they say they have filed some.
Your Lordship, you go to once the proceedings in the High Court.
High Court proceedings are still
Yes.
ongoing.
They have filed some ancillary proceedings according to us.
22nd April.
Much of it.
Item 23.
R1, no counter, R2 has filed.
Also, we have filed the rejoinder also.
You filed a rejoinder?
Yes, madam. We have filed the
To the counter of R2.
Yes, madam.
What about R1? No counter?
No count.
My lord, I have filed the counter affidavit. We have of respondent number 2.
But respond number 1, who's appearing? Rotate. Because this involves a larger question because Anita Hada issue also arises here.
That is the only issue.
So that is the reason why we thought the state would also want to say something on the issue.
Actually, my lord, the question is that after acceptance of his part of the debt is after the lapse of 5 years.
Are you aware of Anita Hada?
Yeah, my lord, I have gone
Then
through that.
you have to answer
Yes, I
that
have.
issue then. And also,
We have filed it. We have filed the rejoinder.
fund number 1 has not chosen to file a counter affidavit. Last opportunity is granted to respond number 1 to do so. List on 23rd March.
Lord, there is an interim order.
Earlier order of state dated 23/3/2025 shall continue to operate till the next year.
Obliged.
Item 24.
R3, no counter.
My lords, I'm seeking some more time.
You're for R3.
I'm appearing for R3.
Counsel for respond number 3 seeks some more time to file a counter affidavit. Usual order. Status quo order dated 25/8/2025 shall continue to operate till the next hearing. List on 25th March.
I'm so grateful.
Item 25.
Lordship, I'm appearing for the petitioner, your lordship.
Counter affidavit in this.
No, lordship, you not received any counter affidavit.
R2 to 4 served, no one is appearing.
Yes, your lordship.
Who
R1
appears for R1? R1, someone has filed appearance.
Yes, your lordship. On 17th January, they filed appearance.
Mr. Ajay Kumar Srivastava.
Yes, your lordship.
Respondent numbers 2 to 4 have not chosen to enter appearance despite service of notice. Respondent number 1 has not filed a counter till date. Last opportunity is granted to the said respondent to do so by the next date of hearing. Within 2 weeks, you said. Within 2 weeks, rejoinder thereto, if any, may be filed within 2 weeks thereafter. Earlier order of stay dated 7/11/2025 shall continue to operate till the next hearing. List on 6th April.
Grateful, your lordship.
Item 26.
Lordship, I'm seeking 3 weeks time to file the rejoinder.
Rejoinder. And counsel for the petitioner seeks to file a rejoinder to the counter affidavit file based on 6th April.
Pleasure.
Earlier interim order dated 13/10/2025 shall continue to operate till the next hearing.
Much obliged.
My lords, we have filed an application for substitution of the LR.
P1 died.
My lords,
P1 died.
my lords, all the legal hairs are already on record. We have
They're already on record.
my lords, we have mentioned in paragraph 5 of the application.
Very well, you'll still have to show them as representing P1 also.
My lords,
So IA numbers 314
7
777 and 314 778.
8. My lords,
IAs are ordered and the legal representatives of deceased petitioner number 1 are brought on record after setting aside the abatement in taking necessary steps in that regard. Full stop.
my lords, I'm requesting,
Amended memo of party shall be filed within 2 weeks. What are you requesting?
2 weeks for rejoinder, my lords.
Rejoinder,
My lords, and status quo may be continued.
rejoinder may be filed. Learned counsel for the petitioner seeks time to file a rejoinder to the counter affidavit of respondent numbers 1 to 5.
Fine.
Needful in that regard shall be done by the next date of hearing. Earlier order of status quo dated 16/7/2025 will stand extended till the next hearing.
My
List
lords,
on
may be kept on NMD,
a non-miscellaneous day.
my lord.
Non-miscellaneous day, you'll be joining the queue there. Anyway, 7th, 8th.
Obliged.
Item 28.
No counter affidavit.
No, my lord, counter has to be filed. The issue is whether the immunity granted by the.
You're for the respondent.
Yes, my lord.
You want time. Learned counsel for the respondent seeks time to file a counter affidavit. Usual order. Earlier order of stay dated 29/8/2025 shall continue to operate till the next hearing. List on 24th.
Grant 4 weeks.
24th.
Yes.
Item 29.
Counter file.
I'm just some time to file a rejoinder.
Rejoinder. Learned counsel for the petitioner seeks time to file a rejoinder to the counter affidavit file. Usual order. Needful shall be done by next date of hearing. Earlier order of status quo dated 4/9/2025 shall stand extended till the next hearing.
So much for the flood. No flood at all.
Okay. We have to carry on. 1/20/26.
31 we filed Wakalanama on this.
For which respondent?
So respondent number first Abhishek Kumar.
1. 2 is not served. You file your counter.
Sure.
Reflects that respondent number 2 remains unserved. Steps shall be taken to complete service of notice upon the said respondent. Learned counsel for respondent number 1 seeks time to file a counter affidavit. Usual order. Okay. Then list on 70.
Item 32.
Please, my lords, I'd like to appear.
Representing the respondent here, my lord, kindly allow me to file my counter affidavit. I'll file it.
Learned counsel for the respondent seeks time to file a counter affidavit. Usual order. 70.
My lords, there is interim relief granted on 21st of November.
21st of November, is it? I'm not noticed that. Very earlier interim order dated 21/11/12/2021.
Obliged, my lords, deeply obliged.
Any specific date?
Yes, dates fixed. What is
7th
that?
of April.
7th of April.
Obliged.
Item 33, my lord, I'm seeking a password, my lord. I'm being
No
late on-
passovers today, please.
Then my lord, kindly keep it, my lord, on Friday or next Monday, please. I'm so
Leave the
sorry.
date to us. Passover is sought, however, the matter is adjourned. List on 3rd February.
No, my lord, kindly keep it next week if possible, please.
Not possible.
I'm sorry.
Same situation will be there. If we clutter up the list, none of the matters will get heard.
Please, I'm grateful.
Item 34.
34 approval,
Settlement is still there.
up to
Waiting for the
approval,
approval.
still waiting.
Still waiting.
How long will it continue?
Let's state. I would have to 4 weeks.
They've settled the matter.
Okay.
Just have it after 4 weeks.
And
This thing
the
is very
authority
clear.
has to settle, has to approve it.
Okay.
So because of that, approval is still awaited from respondent number 2. Who appears for respondent number 2?
Well, it's no one.
You are
There's
for,
no appearance.
you are for
Contesting.
R1. You are R1. List on 7th April.
Obliged, my lords.
Item 35, my lord, with due apologies, my lord, I could not be filed additional evidence with it. I may be permitted to file additional evidence in 3 weeks.
Okay.
Additional evidence.
Evidence, my lord, no evidence is placed on record. my lord. There are some eyewitnesses.
What will
No,
it be?
3 courts concurrently
Well,
found no injury, no
Nothing.
possession of
3
valuable.
weeks as a lost chance.
Eyewitness.
All of you are jewelers, and obviously the
Well, it's-
379 is dropped also.
The other
So your
provisions,
main
my lord,
sheet anchor is gone. That 5 lakh
May I
is
say
not
this-
will.
may I say this, my lord?
With him bringing
May I
additional.
say this, my lord?
Evidence you can't.
May I say this, my lord? Just I wanted to show, my lord,
Yes, sir.
charge sheet kindly have paid 30 and 34, my lord.
Not ordered, no.
No. It
It's
is
a
adjourned.
short
It's
and
adjournment.
There is
3 courts
Well, it is-
concurrently found that.
My lord, such is the case, my lord, I'm pointing out.
Where is the question?
Just
Bringing
pointing
evidence
out-
at the SLP
Just
stage.
let me say something, my lord. Kindly have charge sheet, page 30 and 34,
Where is the
para
question of,
3.
where is the question of
My
looking
lord,
at the charge
370
sheet when
Even
3 courts have
379
acquitted?
goes, 379 goes, my lord, other sections, my lord.
Nothing in it.
Other section, the investigating officer categorically stated that I was beaten.
However, we find no.
341, 506, there are other provisions, my lord.
With the impugned judgment passed by the High Court.
This is all
The
a-
petitions according
This
to
is one of the measures by which
There's no injury report also.
Injury
Injury
report, my lord,
report,
just
five
simply beaten, my lord.
Oh.
Where do I get injury report, my lord? I was beaten
You say
simply.
that you are beaten simply.
Somebody throws out a person, my lord, could not get any injury, such is the case, where do I get?
All courts have held against you. There's no question.
Sure, please.
You want to settle scores with your rival jewelers, you need to think of better ways of doing it.
No, my lord, I was beaten, my lord.
Nothing more.
Item 36.
at times you get beaten in
I'm
the
requesting for a password. I'm led by the Learned Solicitor General.
My lord, it may be taken up with item 90 in that case. This is that matter where Zitco had filed, finally the state has filed an SLP, my lord.
Yes,
Which is that,
state has filed a SLP, but today may not be the right day, so we'll give you a date.
my lord, may kindly keep it, you know, adjourned on 3 occasions.
3 adjournments earlier.
My lord,
One more adjournment is not going to harm you.
it may be taken up with item
36
90.
and 90, Passover is sought, however, the matter stands adjourned. List on 13th March.
My lord,
13th March.
so 15, 15,
Next matter.
Item 37.
Oh, counter affidavit was filed in the miscellaneous application. They say that they were supposed to declare the self-assessment.
Wrong. At no point of time.
Self-assessment 4%.
Exactly. No, that is according to them. But my lords, we have disclosed. And the reason why we are saying this.
No. They've rejected your self-assessment and you.
Yes. Yes.
Instituted
And they were aware of it that it's been rejected. They filed an appeal against that. And then they
Instituted
waited to file this.
Very good. This perhaps we'll take up on another day. May not be possible.
Malos,
today
we
with
file
the
a rejoinder.
Number of.
File
File a rejoinder.
I'll kindly post it on a Tuesday.
Yes.
And finish it out.
Not on a Tuesday, a Wednesday or a Thursday would be better. Tuesdays are also equally, we've got 125
I
matters.
leave it to you. I leave it to you.
So
Malos, then
Wednesday or
notice-
Thursday.
I assume notice is issued.
List on 12th. Well, first week might be a miscellaneous week again. Possibly 19th. 19th March. Rejoinder may be filed in.
In the meanwhile, notice is issued, obviously, in this matter. Notice has not been issued as of now.
We can hear you without notice also.
Malas, then at least Malas will condone the delay since it's gone. I am not.
Let the rejoinder come.
Ask me not to worry. Oblige, Malas. Oblige.
Item
Lordship.
38.
For short.
But you filed an amended SLP straight away, is it? What is this second set that I received yesterday? You need to, this is SLP which you filed, in which you challenged only the 4th July 2024 order.
Yes, sure.
Therefore, if you want to make changes, you need to file an application for amendment. You can't straight away amend it and then say, I'm filing an amended SLP now.
We have filed an additional application regarding the.
Where is the application for amendment?
I'll go through report, Your Worship. I'll give you a short.
There's no application for amendment.
And myself have given to my clerk on Friday. I'll check it.
There's no mention of it, no application filed for amendment. Permission to file additional documents. What does that mean? Copy of the same or miscellaneous documents.
Shall get it? Give me a short.
There is no proof.
Counsel for the petitioner seeks an adjournment. Enable him to verify as to what has been done in this month. List on 7th April.
Oblige, Your Lordship.
My lords, a letter was circulated in this matter.
You don't have a letter. Anyhow, you want an adjournment?
Yes, my lords.
On what ground?
My lord, the arguing counsel is indisposed.
Very good. Adjournment is sought on the ground of ill health of the learned arguing counsel. List on 14th April.
May it please the Lordship. We are challenging the order on 5 grounds, my lord. The first one is complete forgery and fraud with the court. Then, my lord, the second ground is.
Just one information preliminary submission as a caveat for 3-4 respondents. They were directed to deposit 50%. This court dismissed the SLP. Till date that 50% is not deposited, only 10% is deposited. They still seek stay and suppressing the fact that despite extension of time by the High Court, they have not deposited 50%.
They asked for extension of time.
Yes, from the High Court.
That was pending the disposal of the appeal, my lord. Now the appeal was disposed of.
When was that last order?
My lords may have page P32. My lords, the order dated 18th August 25. Page 1079. This was a case when the High Court granted stay subject to 50%.
That was during the pendency of the appeal. Now appeal has been dismissed. We have come before your lordship subject to whatever order is passed. 10% as per the order of this honorable court has been deposited, my lords.
Well, this was interim 10%.
1079 is our order.
Yes, 107 is my lord's order.
Where we rejected that specially.
Yes, and said you would.
No, the.
Please.
With respect, it was still pending.
Yes,
Whether
interim.
is disposed of and they
Lordship dismissed it.
We'll just give you a date. This matter
No.
requires.
5th September, they
Lordship
go
may
for extension of 1 month for deposit of
whatever it is,
50%.
that it is.
They have not deposited and they come up and they say on the amount deposited, the matter he stays. Before this.
We'll consider on the next date.
Lordship will consider next day, Milord.
Pleadings are complete.
Milord, yes, Milord. I may.
Notice as.
Yes, Milord, I may inform my Lord, Milord, one matter is already, Milord, leave granted, Milord, it's pending, Milord. One of the two issues are pending before your Lordship, Milord. This honorable court kindly see the order, Milord.
Different parties, nothing to do.
No, Milord. They are on reliance on this, Milord, they have got that order, Milord. Kindly see. There are two matters which
Same acquisition?
Sorry?
Same acquisition?
Same land acquisition. No. Separate land
Milord, on the issue of, Milord, multiplication factor, Milord, the issue is relying on the judgment of Guwahati High Court, against which this SLP is pending after leave granted, Milord. They have taken the order, Milord, in their favor, Milord. That is also under challenge.
So even there's a 50% deposit condition.
That is a different matter, Milord, so far as that deposit. But then, Milord, this, but they have
not notice and ask you to pay 50%.
Milord, case, Milord, it suffers from fraud, Milord. I say, Milord, it's a case where it suffers from complete fraud. Here, Milord, fraud gets everything.
An implementation of the implementation.
On the condition.
Oh, on a condition that
They
are all not.
Deposit 50%. Land acquisition. We'll consider on the next.
Lordships. Because here is a case which suffers from complete fraud, Milord. Therefore, Milord, that is a distinction.
That order which we passed
Lordship.
shows that you suppressed something there.
No. Milord, that was one list of date, Milord. One list of date. Because
that doesn't
we had
reflect well upon you, does it?
Sorry?
Mr. Sanjay, that didn't reflect well upon you.
I know, Milord. I know.
So let us not say anything about fraud at this stage.
Milord, that I will demonstrate before your Lordship, Milord.
Very good.
Manner in which
27th February.
27th February. Deeply obliged.
41.
So I'm seeking a password in this matter.
Milord, sir,
In any event, what is there in this matter?
Milord, can that matter be on Wednesday or Thursday, Milord?
27th is
That-
perhaps.
Instead of
Is Gupta is gone?
Yes.
Yeah.
any
Very well.
Wednesday.
On a Wednesday, perhaps might be better.
What are the dates?
25th February.
25th.
Grateful.
Great. Mother's next one.
This one over.
Twenty-sixth.
25th.
25th.
Deeply obliged.
Great.
Very anxious.
41.
Wait, please, sir.
According to you, leave that technical issue. You may
Yes.
have a point there. But your lease is over in 2020.
It is not, that's absolutely incorrect.
Where is the extension after the
If your lordship see the receipts, just see page.
Where is the extension?
Yes, I'll just show
No,
that.
even otherwise, your case is that you are not in possession, your mother is in possession.
My mother is in
So
possession.
then what is your problem?
Not hand, through her hand only.
No, she
Your
is
mother,
agreed, she
your
has
mother
to
is
come.
still alive.
Just see 30.
See, your mother
If
is
she
still
is
alive.
aggrieved, she has to come. Why has she not come?
Your mother is alive. Have you ever said that anywhere? Your specific contention is that I am not in possession. The mother is in possession. But if the mother feels that her suit could not have been dismissed, she should come here, not you. You should not.
Ground A and B, you said he was never in possession, mother was at party. You're not
Mother
inclined to
can come.
entertain.
My lord may
Take a
reserve the
note,
liberty for the mother, my lord, at least. Otherwise,
You find no grounds to entertain the special leave petition at the behest of the petitioner.
Yes.
In the light of his clear stand that he
Lord,
was,
may I make one submission, my lord?
he was never in possession of the leased land. especially petitions according to this.
My lords, may I just make one submission, my lord? I am just informed the mother is also filed in SLP, my lord. This may be taken up in that one.
No, we've already said that at the behest of you. Dismissed at the behest of you.
Very well. Very well.
43.
43. Yes. Respondent minutes.
What happened before the
So it was heard on 14, 15, 16. Today it's kept for rejoinder conclusion at 2 p.m.
Mellows, I appear
These are the
the
orders.
appellant.
Nothing.
Mellows may have it after 1 week. It's kept
Correct.
today for rejoinder arguments.
Correct. We are informed that the NCLAT is presently seized of the
Can I
matter, taking up the matter today.
Today,
Yes,
can I just
today at 2
can-
p.m. The counsel for the
Wants to
respondent
say
wasn't
something.
available
Yes.
on the last date.
My lord, can I just say something, Lord?
Yes.
I appear for the respondent. My lord, we've argued this matter for 3 days. Due to a health issue on our side, the matter has to be only kept today for 15 minutes. So, my lord, my request is if my learned friends are keeping this appeal alive, then my lordship may have it after 10 to 14 days because today it will be reserved. I myself made the submission before NCLAT that please reserve it. We are filing written submissions also today.
20th March.
Grateful.
Obliged, Mellows.
Wait.
Wait, please, my lords.
Yes.
Just take this 2 points is better put here. Kindly turn in this note to page. Sorry, give a copy immediately. To page.
One moment, Dr.
3 minutes.
1 moment.
Where is that? Just turn to page 3 of this note. I'll only read a few paragraphs, not. It was para 1A. Take third line. There was no prayer, the specific prayer seeking recovery of possession of any quantified built-up area. My lords can check 155 of the claim. Don't need to go there. I put the page. There is no specific prayer. Now look at this B Malas. The award declined these 2 Malas basic prayers. The award against me declined these 2 prayers. Next para. 1, cancellation of JDAs declined, and declare sale deed null and void declined. Then did Malas complete rewriting on an ad hoc basis saying, in lieu thereof, a direction for recovery of possession of the owner's entire super built up area, para 91, page 261, with no Malas, this is a rewrite, there is no such contract of any kind. Then Malas, section 34 court in my favor. I am today in a reversal order. 37 reversed my 34 in my favor. Held that when no relief is prayed for, the tribunal wrongly granted relief not pleaded, proved or prayed and further dealt with the consequential directions. So this is my favor. Now ignore D, come to E. Cancellation of JDAs and sale deed and a direction for delivery of possession of specific built up area is justified by the impugned order by saying it's a lesser relief. There can't be a lesser relief. The 2 are distinct executable decretal orders. The High Court's approach effectively grants an unplayed relief by labeling it as a lesser relief, which dilutes the permissible statutory limits of arbitral jurisdiction and McDermott. Your Lordship doesn't allow rewriting in this one. Now, 3 pointers. The second point is then I come to the third one. In the second one, para 2A. Now, this is the first part, that there was no specific prayer seeking damages. That's repeated. Now come to 2B. Yet the arbitrator at para 62, page 195, gives damages of 83 crores. That's crores, 83.96 is crores. And continuing monthly payments of 89 per month. The 34 court in my favor at para 12 found this reasoning of the arbitrator to be in gross violation of the terms of the agreement. At para 16, that is the 34 court, it notes that based on a government order of 1996, which is at page 68 to 69, the noting, the petitioner could have started construction without waiting for sanctioned plans. It should be could not have. Could not have, right? Yeah. That's a misprint.
Could have started.
Oh, sorry, could have. I'm sorry, but it's could have. The section 34 holds that question of liability arises only upon completion. Now, this point is important for my third point, which is the date. The date is wrongly taken, but there are three dates: Bhumi Pujan, date of construction start, or date of sanction of plans. They take Bhumi Pujan as the earliest, whereas the latest had to be taken. In any case, I have got sanction plan date. So you have to take it. That's coming in the next point. Just give me a minute. The Honorable High Court in by D. has observed in para 24 that the arbitrators balance the situation. What the 37 reversal is basically based on broad, equitable ad hoc approaches. Now come to 3 Malas. This is very, 2.1. 2.1 does my lord have?
Yes.
This is a very important point. I am assuming without conceding the damages are payable. No pleading, no Malas is approved, but I am assuming. Now this is important, Malas 2.1. Even then, the date has to be 28/10 and not 1/11. Why, Malas? 28/10 is the date of sanction plan. I hope I'm clear with this.
Yes.
Now come to A. All three JDAs clearly say in 8H, page is given 97, that for the period of completion of construction shall be 24 months from Bhumi Pujan, or date when construction actually commences, or date of receiving plans, whichever is later. In a specific question in the cross, when asked, the other side witness in the middle of that para at page 187 at para 50 admits that the period of construction for the period shall be computed from any of the above three dates, whichever is later. 8K says that if construction is not complete in 24 months, the developer will have an additional 6 months to complete construction, during which they will get compensation of 15 rupees per square month. Before 6 months, the JDA to stand automatically terminated. 10E says that from the date of completion, the developer will have 6 months, etc. I'll skip that. Now, here, the sanctioned plan date is 28/10/11. Yet, let us come to B at page 5B. Yet at para 50, page 187, the arbitrator accepts Bhumi Pujan date, that is 2006. That is 5 years earlier. 5 years earlier, as the date from which the 24-month period would commence. Even though admittedly the sanctioned building plans were received only in November 2011. That's a typo. That's 20th October, not 20th November. It should be 1 month early. It doesn't make a difference because I have been given an award of 2006. The starting point is 20th October 11, not 20th November. Well, your lordship gets a 3-year hiatus, so the damages will then start from 2014. Just give me a minute on that. This the arbitrator does only on the limited point that R1 had stated in an old communication that though the contract provided exactly as what is being said, it may not be correct morally. Let's kindly see this. 2006 given on the ground that 11 may not be morally correct date. If 11 is the date, then damages have to be computed from 2014. I hope I'm clear on this. It has to start from 2014. Yet the arbitrator takes the moral standpoint as to the basis to treat Bhumi Pujan. Now, damages for loss of rent from 11 to 21 is 83, continuing monthly payments. Then we'll ignore C, come to D. The section 34 court holds that the question of liability for rent arises only upon completion of building, and the grant of damages, and that too beyond the contractual period of 8 years, is erroneous. Despite this, the High Court in my impugned order of 37 has observed at para 19 that the arbitrator is correct in adopting the moralistic argument contrary to the written JDA's. And then F, the impugned order upholds the arbitrator's view, fixing October 11 as the only view. It will be perverse to reckon completion times from the later sanction plan date if that ignores the actual completion admissions. It further relies on post-contractual emails to find that parties had given a go-by to the contractual stipulation. Well, this requires consideration. This is written totally as if it's some kind of a equitable order.
But you wrote to them saying that you would start paying rent from April 2009 itself. You wrote to them. There's a letter. It's not just a question of you saying that it's
Yeah.
morally wrong.
No, just see. Partly answered in G, Manas. It's incorrect because firstly, first of all, contractual clause, 2810, the sanction plan date has to be treated. G, Manas. G.
This letter which is referred to, where is that?
Yes, we just show the letter. 2009 letter. Go to the page.
189, he produced.
It's the real purpose. 189.
12th January 2009.
At 189, actual letter. Where is the actual letter? It's mentioned at 189. Not here? Well, let's just come to 189. It's partly quoted. In fact, all the relevant part is quoted. In paragraph
12th January 2009.
Yes, at
That
paragraph
letter.
53, Malas. The first prerequisite before the property could be tenanted is answer it. Building could have been complete to extent possible to move in with such mind. The first communication that is available is 2009 under Exhibit 21, in which they expresses gratitude.
We shall start getting rent from 1/4. What does that mean?
We have finally concluded with the client. I shall send you the agreement early next year.
So that is with regard to some tenant or someone, is it?
Yes. We shall start getting rent from 149. That never happened. We never started getting rent from 1409.
See, how do you say that when your sanction plan was not there at that time?
Yes.
They
So
started construction. They started construction.
Sanction
because
plan
that
came
GO
only in 2011.
The GO was permitted them to start. You started construction in 2009 itself.
10 or 9?
9.
Yes. Before 9. So
Before 2009.
6 itself. 6. We started construction.
6 itself.
Yes. Now let's just see G.
They have invested tenants
1G.
before.
When did you allow occupants into the building without a sanction plan itself? How will you do that?
When did you allow occupants? Only 17.
This is in Chennai.
Only 17.
Then why did you take this undertaking? That
Coimbatore.
Coimbatore. But
Only
the
from
same laws
70.
would apply because I dealt with that Madras property
No, my
matter.
thoughts query about occupation.
Perhaps you appeared in that Madras property matter. The Madras property, Lancor Holdings.
Ah, yes.
You appeared.
Yes.
So you could not get water and electricity without an occupant.
No, therefore the occupation is 2017, Manas, admittedly. Occupation
Why do you say
2017.
that we
We'll
should
get rent
get rent
from
from that
2008.
Manas, it never happened. It's a tentative communication of 9. Can't go right the contract. The fact never happened. I understand, Rubala. It's a
But what
casual
exactly does
communication,
that
good time.
letter? This is some email that you're
Yeah,
referring.
but this is a good time. Well, we will not.
No, but 12th January 2009 letter, what did you say?
This only, Manas, that we will get rent from.
This is your email perhaps.
So this quoted, Manas, that thing
There
quoted
are
below
two
is that.
things there. You seem to have sent an email as
This
well
is
as a
same.
letter.
Huh? So this letter which you'll also be asking is quoted in para 53. 12 January is quoted. It's in the email.
There seems to be an email dated 24th December 2008, followed by a letter dated 12th January 2009.
2008 we don't have here, but just
So-
check up. Just check up.
This
This is
extract,
the-
is it from the email or from the letter?
This is from 12 January. Manas.
This is from the
12th
12th January.
Yes. Well, just see my note, para G. These are the 3 legal grounds, Manas, which arise on the date. Firstly, 2811.
Does the High Court infer that there's a novation of the contract?
No.
basing on
It says, the High Court in 37 says simple. The arbitrator did a moralistic conclusion.
using
That
that
moralistic-
word also?
Yes, please come to that. That's very important. Come to para B on the same page 5.
No,
That's
in
my
the,
problem.
in the body of the judgment, where does he say?
Yes.
The division bench, where does it say that?
This correct morally.
Moralistic.
That is not correct. Which page?
Moralistic and
I get it. In the arbitrator's award, it is there. Manas. That's all.
no. You said that the division bench has also upheld that
Division
by
bench
using the
says-
word moralistic.
Division bench says that upholding this, we are not wrong. The arbitrator took that stand. First, see, Manas, page.
There's only a
49.
reference to what you yourself said that it is
First,
not
the
correct
arbitrator award.
morally.
First, let me show the arbitrator, and 49 is the division bench. 49 is the division bench, show the arbitrator the award.
49 only says that when the arbitrator has balanced
The
the
division on that ground, but I must take out the arbitrator's award. 187 is the arbitrator's award. Arbitrator's award. Just come to that. You also will get the context then.
He says this is 7.
Yes, just come to that. Give me that 11 line. This is the. Please give me the work. Model correctly.
Let's see. When did the construction commence? Soon after Bhumi Puja.
Further, as per agreement, my commitment legally starts only 24 months after getting complete plan. And we have not yet got the full sanction officially. So most of the claims, I can hide behind this, but it is not correct morally. This is my witness saying this. Turn the page, Wallace. Now the learned judge in the division bench says at page 49. Page 49. This is very long here. At page 49.
Yes.
No, 49 is here.
Did they get a multi-story approval in 2008?
No.
Middle of 49. You're taking a broad equitable to the middle of 49.
What do you call?
49.
Yes.
49.
Did you have an initial approval of a plan and thereafter a final approval?
What is this about a multi-story approval?
Well, we need to have approval to generally start. The sanction plan comes in 11.
2011. That's the final sanction plan.
That is the sanction.
But
we
you
need
had an
permission to
initial
start.
sanction plan.
No, well, we need permission to start. We need to file papers. I mean, those papers we can file in a compilation.
You don't have to have a sanction plan to start construction.
Well, apparently
That
not,
GO
because
that
apparently
GO
not. I mean, I
seems
can't, I find it in Delhi, certainly not. In certainly for IT parks, I'm told there is an exemption. I can put those papers on record. That GO of 96
permits you to start
for
construction.
an IT park exception. Even then, well, there have to be papers, but maybe not a sanction plan. I mean, I'll need to get
What
those.
papers would you need?
No, I need to file all the my architect's plan. I'll need to file.
Setbacks need to be maintained.
No, I'll need to file an
Whatever you
architect's
do
plan.
internally is
Yes.
one thing.
You don't need a prior sanction is all that may mean. It may mean.
For a
IT park, this is what they are saying, but I need to, we've got those papers in the arbitral award. Just see this 49, the approach is, I'm on the approach,
Yes.
see page 49. This is 49, 45. Why are you? 45. Why do you change? Now, first of all, the morally correct part. My problem was I was a bit too honest. I started talking of morality in my witness box. It's okay, but that can't be the basis of an award. 45. Turning to the email of the developer of 2008 and 9, although they treat 12 January also as an email, it is obviously clear that the developer has conceded that taking cover under the expression whichever is later is not correct morally. I don't know why my man said so.
Execution proceedings have been initiated.
Just come to
Yes, please.
yes.
You have.
Yes.
Yeah, we have.
Yes. Yes or no? We haven't not got notice, but they will know better.
Just see page 16.
60.
1/6.
Yes.
Well, can I just 5 seconds? 45. Just see for a minute. To connect this, I'll come to that immediately. It is obvious third line that the developer, that is me, has conceded that taking cover under the whichever is later, which is contractual, is not morally correct, and he will see to it that rent starts coming from 9. That's a letter which never got acted upon. Now, on this C49, page 49, he gives a finding saying the arbitrator is not wrong in following this. Middle of 49. When the arbitrator has balanced the situation, taking into consideration the overall facts, granting the lesser relief than the relief sought, the same cannot be taken. This is the approach. It's done on a very mediation basis.
This is correct. 8/7.
16 or 16?
No, but have you seen 19?
16 is.
As per the claimants, the date of multi-story building plan approval is the date of commencement of construction.
Same one.
So then you commence.
This is the contention part. This is contention. Let me read that. As per the claimant, the date of multi-story plan approval of 18th of July is the date of commencement of the construction. The 24 months time to complete the construction ends before 2010. According to developer, the date of completion is record. But obviously not, because the contract says Bhumi Pujan, sanction or construction.
What is the nature of this approval? It's not a sanction plan.
No, it is certainly not a sanction.
But you,
Because it is common ground that it came in October 2011.
but you obviously started construction even before that.
Well, is that I'm told, but either Lord should allow me to file the second volume because I don't want to. That IT parks don't need a prior sanction, which I don't know about. I'll have to file those papers.
So again, the sanction plan has no what do you call validity if it doesn't need a what do you call
Mainly IT parks must be giving the
sanction plan is not required for construction or for inducting tenants. And as far as they are concerned, they are only concerned with the construction and the
no, induction of tenant happened in 2017. Well, you can't induct.
One. There are definitely debatable points.
Because I'm going to request
because the arbitrator has rewritten the contract.
Because I'm going to
To what extent that was permissible given the fact situation in this case, perhaps we'll need to examine it.
Because I'm going to.
But there are at least issues that need to be looked at.
All right. So can I just respond? I'm requesting you with folded hands. Please don't touch this and just listen to the facts. The arbitral tribunal has described this as diabolic, what he has done. Now just listen to why they said so. My agreements are of 2006 and 2007. I gave 8 acres of land to this developer. He was to give me 20, the consideration is primarily in kind. Some small amount of 1.6 crores was given at the time of execution. And
you get 20.
Now just, can you imagine? From 2006, 2007 onwards, I have not received a brass farthing and I have not received a single square foot of area. Now just have a look at this, please. Just have a look at this. Give it to them. Come on. Write down number 1. Yeah. Oh, give it to me, driver.
Would you have made them a little smaller?
Yeah,
so that they would fit into the 5?
That's to impress your lordship.
These are the
towers. Now, just a second. Now, I'm just going to explain to you. These are the 2 towers which are up. It's the IT park which is up, right? He has to give me a little less than 2 lakh square feet of this tower. He has to give it to me. 20% of my entitlement. He identifies, and I'm going to show that to you before the arbitral tribunal. He acknowledges that yes, I have to give the whole of Tower C, which I have marked, and a little portion of Tower D. He has till date not given on the front, on the very first, we've written C and D.
C and D.
The whole of C is to come to me. The whole of D, a portion of D is to come to me. He acknowledges that. He has till date not given it to me.
Get 20% only.
Yes, 20% because it's out of the 8 acres of land and developed area. But this is not.
How many more would be coming up?
So that he may construct more, but that's a separate. Now, just let me just go step by step. He has inducted. You will see on one of the pages. The idea is to sort of put counsel at a disadvantage. So I don't have a copy of what is handed over. But anyway, the point here is that they have inducted. Your lordships will see. Just see the 4th page. I believe it should be on the 4th page. They have inducted all these people and are gaining a revenue stream. For the first, your lordship is seeing. So he's got this continuous revenue stream for this. He hasn't parted with 1 brass farthing. Though, so this area is for me. He has inducted tenants and is earning a revenue stream. Not 1 rupee being given to me. Now, please, and now I'll develop the point. Now go to page 200, please, of the arbitral award. And what the arbitrator says is, it's a waste of national assets. If I have to, you are in breach. It's a waste of national asset. I'm not going to allow these buildings to come down and be torn down. And therefore, he records their submission. Now go to 200. Issue 16 and 17.
No,
a case of, your lordship has
that. We need clarity on one issue.
Yes, of course.
How many buildings are to come up on this 8 acres?
That is on the basis
MOU.
of, that's on the basis of built up, sorry.
As per your MOU.
Yes, so therefore more buildings can come up. Please just see the 3rd sheet is this particular, the open area.
Yes.
Which shows the entire area. There are patches which are still open, where construction can come up.
Very good.
Right? Now just go to page 200.
No, but where do you get it that he promised 20% of these 2 towers which have already come up?
Yes, that 200. Just go to 200. Page 200. Now this is the arbitral award. Your lordship has issue 16 and 17.
Yeah.
You'll find it very rare that, at least in my experience, it rarely happens. A case of diabolic fraud by the respondents, but we'll still retain the benefit of the purchase as a measure of exigency, the several circumstances. Your Lordship has that.
Yeah.
Now, please go to about 7 or 8 lines on that first paragraph 66.
Yes.
If the relief of setting aside the same is not given, it is only on account of the fact that it is inexigent to do so. 2 towers have been erected at considerable cost and labor. It will be a vast waste of national resources if the built-in labor is negated. By setting aside the JDAs, any bilateral document such as JDAs can be set aside only if there had been a vitiating circumstance. I can say that it was surely an unhealthy bargain for the claimants when they parted with 80% of the land and securing a mere 20% of construction that was assured by the FSI admissible. The conduct of RW1 and the council has been brazenly defined and unfortunately exceedingly unfair. The respondents who obtained the benefit of 80% of the land for a consideration of construction promised to be made and delivered has admittedly not delivered the property. The promise to deliver has been moonshine, and even a straightforward answer by RW1 admitting his liability to deliver possession of the property in evidence to my question has not been accompanied by any action to bring the value to promise. I shall reproduce the response to my question during the course of cross-examination on 26th August 2001. Question from the arbitrator. Are you prepared to deliver up Tower D and a portion of Tower C, which you claim to have earmarked for owner's share, and file a memo to that effect even tomorrow? Yes, I am prepared to do so without prejudice to the rights and contentions of the parties. He says this. Now see, the counsel for the respondent would not allow the admission to come to fruition. After witness evidence was concluded, and when I was drawing up the minutes on 26th August 2021, the counsel dithered and said that he would take some advice from his senior counsel to carry out the offer to deliver possession. He changed his stance and said through an affidavit that of the party that there are several obligations to be performed by the claimants, such as sharing of expenses incurred by the respondent number 1 to make it habitable. I said that whatever expenses have been incurred should be adjusted against the rents because the rent stream has begun. At the time of arguments, he had another new contention to make that I had exceeded my jurisdiction in asking questions to the witness about the surrender of possession, and that if only the claimant was given up all the claims against the respondent, he can deliver possession. Yet another fanciful contention was that the sale deed did not contain 80% land and there is a shortfall of 16 cents. This is a contention which has no support in the pleadings. At all times, the claim statement and in the recital in the documents themselves, the respondent had secured through these documents aggregate of 80% of the whole. Now, please go to para 66. Unfortunately, till date, the respondents have not even given the plan for the construction made to identify the extent as 69. My mistake. Okay, I'll read 68. If all these actions, it can be seen that the respondents were not prepared to go so far as to state that they were not able to surrender possession because that would have meant failure of consideration for the sale obtained under Exhibit C8, 9 and 10. Here is a case of the respondents adopting a dog in the manger policy. Surely would not let go of all the property which he recognizes as the claimants and not to forsake the claim of 80% share. Unfortunately, till date, the respondents have not given the plan for the construction made to identify the extent as actually available. I will find that the respondents are bound to deliver to the claimants so-and-so square feet from Tower C and Tower D. I attempted to secure the details, etc. through documentary collaboration, etc. Now, let's just pause here for a moment. So just see 2-3 things. What has the arbitrator eventually done? He said that, yes, they had asked for termination. This party is in breach, etc. But there's a national asset over here. Your lordships have seen the photographs. So I am not going to do that. He has recorded a statement saying of the developer saying that I'm willing to give the whole of Tower C and D. So what they do eventually is, just see this. You have got hold, you have put up this and you have recognized that this property is to come. I am entitled to 20% of the completed area. You have inducted third parties. Now just note one thing. The revenue stream for those 8 years is to come to me for the first 8 years. So he inducts third parties and he gets that revenue from those third parties and he doesn't give it to me.
So
my obligation was to share.
What do you mean you need to get it?
I'll tell you why. Because this was IT. Let me just tell you, this was an IT park. So I had the land, but I didn't have the wherewithal to identify persons who would come in. So therefore, the arrangement between the parties was that for the first 8 years, they would identify people who are in the IT sector who need 2 floors, 3 floors, whatever it is. So he's brought them in. So just imagine, he's got 8 acres of my land. He has getting this revenue stream. He has not given anything by way of consideration till this late date of, till this point of time. Now, just 2006, 2007 are my agreements, my lords. So the arbitrator, I'll take you to the arbitrator's final deposition. But just note that the first respondent is 93 years of age. Second and third respondents, who are the owners of the land, are 70 and 73 years of age. Now just see what the arbitrator, after getting into this, just see the fair relief which has eventually been passed. Just have a look, please, at page 216. The question I ask myself is, why interfere in this? Please look at 6. Please do. Because the principle, my lords, your lordship's principle is that, look, even if a pleading is not there, if the parties knew exactly what was at stake and arranged it before the arbitrator, they contested the case on that basis, there's no question of some technicality, no prayer, no this, no that. Now, please see, in the result, the relief setting aside the sales and cancellation of JDAs is declined, and in lieu thereof, the claimants are granted the relief of recovery of possession of so-and-so square feet of built-up area as corresponding to 2.67 FSI within the undermentioned property. This shall come from Tower D in full, which is said to be so-and-so, and the balance will come from Tower C. Along with this shall be the entire car park of Tower D and the place earmarked for in Tower C that will be proportionate to the built-up area to the claimant. The damages for the period immediately prior of 6 months immediately on completion of 24 months from 1st November 2008 is declined. The relief of damages for loss of rent for the claimants 1 to 3 shall be from 1st November 2011 till October 2021 for a sum of so-and-so, which is the aggregate amount payable as calculated as per paragraph 65 of the order. The respondent shall be liable to pay the claimant for each month commencing from 1st November 2021 an amount of rupees so-and-so till the date of delivery of possession of the property. The amount determined as payable to the claimant shall be apportioned amongst themselves. The amounts determined shall constitute a charge over 80% of the property of the respondents that have to be transferred through Exhibit C8 to C10 in the schedule below in priority of the mortgage created in favor of LIC housing. The claim of damages for the capital gain notice received by claimants 1 to 3 is declined, subject, however, to any amount in excess of the amounts, etc. The respondents are restrained from selling their property without performing their obligations under the joint development agreement. The respondents are liable for the amount determined to pay at 15%, to pay interest at 15% per annum. The claimant are entitled to a cost of arbitration of so-and-so. Now, my lords, there are certain other segments of this particular order, which of the arbitral award, which I would also like to place. Yes, sorry, FN? Yes. Yes, so F and G, my lords, will not be eventually, because the High Court has not allowed those two portions of the directions. So that legal issue doesn't really remain. Now, my lords, just have a look. Please have a look at 2-3 other elements. Please just, there was a question which the court had put. Just go straight away to page 1. Sorry.
See, F is declined only to the extent of the mortgage being subject to the charge here. The loan was cleared. The loan was cleared to the LIC before that was cleared.
They have created a charge.
No, that was cleared earlier. LIC's loan was cleared. That was why the High Court said that.
Yeah.
That is not there. But then the charge remains with you even then, is it not? F remains.
The priority, my lords, in payment, repayment will remain with us. But, my lords, I'm just asking myself, my lords, when people part with land in two, now whatever the bargain was originally, when you have 2 towers which have come up like this and the gentleman has given me nothing.
Buildings completed?
These buildings, my lords, have been completed at least, your
For
lordship.
quite a
just
while by the looks of the nameplates at page 4.
17 months, 2017.
And since then, you've not given them anything.
Anything at all?
I'll tell you this immediately. He's arguing on prejudice. I'll answer on prejudice. I'll answer on
Yes or no?
Yes.
Have you given them
And I
anything?
have approached them 3 times. He filed criminal cases against me from 11.
You approached them with what?
No, refused to criminal cases against me, refused to settle. They are all quashed in my favor. I have offered him now, Malas, the building.
You made a statement before the arbitrator.
Yes, well, that is later. Give me 2 minutes. Just it'll solve the problem. He is entitled under clause 20%. He admits at page 109 is the clause. That translates to 1,95,000 square feet. I'll give it within 1 month. Number 1, prejudice. Prejudice number 2.
Okay, no.
I received the first brass farthing, to use my friend's language, of rent in 2017. He was hot-footing my criminal cases. I tried to mediate with him. I will bill him the entire rent from then 2017 till today of his share with interest in 4 weeks. That's the
How much is that?
whatever is the amount.
No, you tell us what the figure is.
It's about 20 crores. It's not a small amount.
You are supposed to pay him now 83 crores.
Therefore, Malas,
83
my
crores.
payment is for 17 to today. With interest, I will pay. With prejudice, I'm saying.
Someone who has parted with 8 acres of land.
How? Why did you put 8 acres? You will get a loan. Justice Chandran's question, I will have paid the loan, relieved the charge of LIC.
That's the different thing.
That's the reason he came to me.
See, that's a different thing altogether. You have to release the charge
Malas,
first.
today,
Otherwise, the priority would have been.
May I say one thing? Prejudice cannot take the place of law. Page 98, the clause is whichever is later. Page 98, the clause is whichever is later.
They are entitled to interest.
The 2 clauses that he has is all rent due to him with interest from 17 over 20 crores he will get. He will get 1 lakh feet, which is ready from rental only. 1 lakh.
If this building was complete, I mean, to just test your bona fides.
Yes.
Even if you thought he was entitled to a portion of this building, that 20% of this building and this other building, you ought to have offered him.
No, therefore was 20. That's my witness offered.
Never did that.
My witness offered.
Where? He said that he would take the entire building.
No, he offered, he read it.
He said the entire Tower D and a part of.
Yes, it has to come to me, my lords. That is the share.
So even if you made that statement, you didn't want to stand by it.
No, well,
At least 20% of each building you ought to have offered.
21 till now, the relations have been so bad, they're filing criminal case. That's why it didn't happen. Today, Malas, your lordship is sizing of the matter. The building is entirely his maximum claim, according to him, is clause 2B at page 109, which is 20% of this buildings. He can have it in 4 weeks from today. 4 weeks from today. His entire claim is 20 crores plus interest. He can have it down.
In some cases, perhaps we have to look beyond the legal point.
The lordship will not allow an unjust order contrary to law to stand because of equity and prejudice. Just because the arbitrator is
4 years.
Well, just
we are not trying to entertain.
Just because the arbitrator is prejudiced, because of these facts, your lordship will not allow
is according
prejudice to stand in the way of fact. The clause at 98 says whichever is later.
Look at the facts also sometimes. Law can't stand.
Well, that is based on
the injustice that is
both.
You have been completely unjust.
Because he gets full 98, full balance within 4 weeks.
Completely unjust.
With interest.
Nothing.
Obliged.
What happened to this matter?
Lord, here the High Court has kept it on the 29th.
29th.
Your lordships could keep it in the middle of February.
We are informed that the High Court is seized of the matter and has adjourned it to 29 January. List on 10th March.
I will introduce the orders. Why did the High Court do it? They deposited the money.
46, Lordship, give me some accommodation. Lordship, I got an injury.
Sorry, 46, is it?
Lordship, I'm for the state. Lordship, give me some sort accommodation. I got an injury.
As per the office report, the High Court records are received, the trial court records are not received.
Not received.
Whatever that means. You'll need the trial court records.
Yes, no, trial court records. Because there is a letter circulated by the counsel for the respondent.
Registry is directed to follow up with the follow-up and requisition the trial court records at the earliest. You've already received the High Court.
High Court order is on 17th, Lord, I have received this month.
On
Right, okay.
We'll take it up on a Wednesday.
Please.
8th April.
Much obliged. Much obliged.
Please.
47. Only the IA is listed.
Russia seeking accommodation. Russia London Senior Counsel is not well today. Any next
Government is sought on the ground that the Learned Arguing Council is indisposed today. Placed on 27th February.
Lordship, next week if it is possible. Lordship,
You've been inside for 1 year and odd.
I was.
So even according to para 13 of your suspension of sentence application, 4 years sentence is adequate. So once you said that, at least remain there for 4 years. Then.
Petitioner's wife is hailing your Lordship.
That doesn't mean that
next week, your Lordship.
you've already been let off lightly. The sentence is reduced, is it not?
No, High Court said.
No, your Lordship. I was
Oh, I see. This is 302. Earlier was 4. Earlier was 4 years. Now it's 302. 302.
Any earlier?
27th.
In this, may I seek permission to serve the complainant through the SHO, my lords? He has appeared in the High Court. The address of
taken though.
No, please, what happened, my lords? I've given 2 different addresses. I've tried substituted service.
According to the office report, since the last date, you have not taken any steps
Lords,
at all.
I have not been able to trace him at all, my lords. May I only place the facts, my lords? This honorable court gave me 2 opportunities. I gave fresh particulars. I also effected substituted service.
Learned counsel for the petitioner seeks some more time to effect service of notice upon respond number 2.
My lordship may say through the SHO, my lords, because the same address, he appeared in the High Court. Here he is not appearing, my lords. I'm only saying with the help of the state, my lords. Otherwise,
So we'll serve it through the SHO, the Lordship.
Such service may also be effected through the jurisdictional police station.
I'm deeply obliged, my lords.
Item 49. The Lordships are being led by the London ASG is caught up in court number 5, but either ways the trial court records were requested.
The service is also not complete in the as per office report.
Service is incomplete.
On respondents 1 and 3.
As per the office report, I don't have the office report. Just mention that. As per the office report, service is still incomplete.
Office report.
Steps shall be taken to complete service of notice upon the unserved respondents. What about counters?
It has to be. You have to find counter.
You are for?
Number 2. I am
R2.
Respond
You had asked for time earlier?
Yes, my lord. We had asked for time.
Learned counsel for respond number 2 seeks some more time to file a counter application. Usual order. List on. Sorry? Original trial court registry is directed to follow up with the trial court and requisition the records. With regard to that also. And list on 20th April.
The Lordships may please mark the ASG's presence.
Without the ASG being present, the ASG's presence will not be marked. Your presence will be marked if you get anything out of it.
Highly obliged. Thank you.
Item 50.
In item
50.
Item 50 on the previous occasion, your lords were pleased to permit us to bring on record information about the legal heirs of the one deceased person. We have now filed an IA to bring on record that information.
Only one?
The IA is 3153.
How many persons died?
Only one person.
Only one person died. So these are the
Yes, ma'am.
issue note IA number 315386 of 2025. Issue notice to the
My lords, I have a submission to make, if I may be heard. Instead of including each of these legal heirs, my suggestion is that the amount can be deposited in the trial court.
Without hearing them, where is the question?
My lords, if I may just pass on an order.
How many are there?
There are totally 8 heirs.
Very well, let them come forward.
My lords, if I can just pass on one order. Where the
It can't be behind their back. Where is the question?
In a similar case, that was the thing.
Well,
Because
that is not the procedure I would like to follow.
the reason is that each of these
That's not a binding
council.
procedure. List on 7th April.
Item 51.
My lords, in item 51, I beg to appear on behalf of respondent number 224. My lords, I am praying for a week's time to file counter.
You entered appearance? Not yet.
My lord, I have it.
You filed your vakalat?
Vakalat number is there.
And counsel appearing for respond numbers 2 to 4. Takes time to file a counter. Usual order after that. List on 24th March.
Malos, the state's counter is on record, Malos, in this one.
Counter affidavit filed by the state is taken on record. Rejoinder thereto, if any, may be filed by the magistrate.
52.
52.
52, I appear for respondent 1 and 2. Malos.
Are you
Limited
interested in
limited notice
for settlement? We'll go before the mediation.
Can we make some arrangement? I have discussed with my learned friend. If this matter meanwhile can be sent to mediation also.
You want to
It is
go for
130.
mediation?
Item 50 also.
Very good. Mediation, that one also. That R224 counter affidavit in the event mediation fails there. Then appear before the mediator on 5th February.
Grateful.
Then item 52 also appear before the mediator on 6th February.
Grateful, madam. Keep your pleasure.
No counter affidavit,
Milord, not required.
not required.
2 weeks sentence imposed, not 10 days undergone. Milord may leave him on the
Exemption from surrendering already granted.
leave him on the under. 2 weeks is the sentence under 320.
Cast abuse, attacked with a sword, is it?
No, not so. The spade.
Spade.
They were it's in the field, agricultural field. The dispute took place.
Very.
My lords, only one submission, my lords. Compensation was ordered, my lords. He is one for 1 lakh, my lords. He is only farmer, my lords. There is no, my lords.
Compensation payable to the victim.
Yes, my lords.
There is a question of setting aside that without the victim being before us.
No. My lords, already fine was granted, my lords. 1,000 rupees has been imposed.
Compensation we cannot set aside in the
Time
of the
is
victim.
357, my lords.
If it doesn't go benefit.
357, CRPC 357, my lords. Compensation.
In any event, we can't
Only
touch
if there
it.
is no fine, my lords, then compensation.
We cannot touch it in the absence of the victim before us. Please understand that.
We may implement that.
Implead then. And counsel for the petitioner seeks time to implead the victim who has been granted compensation. Steps in that regard shall be taken within 2 weeks. List on 4 weeks. 4 weeks list on.
He's not on bail.
His exemption is on 6th April. Exemption from surrendering granted earlier. Shall stand extended till the.
They suggest, my lords, we are ready to pay 25,000, my lords.
We already told you we can't change anything in the absence of the victim.
Item 54.
No passovers today. Yes.
3 weeks time to file account.
Very good. Then counsel appearing for the state of Tamil Nadu seeks time to file a counter affidavit, usual order, list on 6th April, 7th April.
My lord, I am seeking more 2 weeks time.
In
As
55.
55 lords. As students
Counter.
are residing in different cities, and I just got Vakalat on behalf of cancer patient respondent number 3.
You are appearing for which?
All respondents.
All the respondents. And counsel appearing for the respondents seeks time to file a counter affidavit, usual order, 7th April.
So great.
Item 56. Was any fixed date, Milords?
7th April.
So great.
56, there's a letter.
My request.
Adjournment is sought by the learned counsel for respondent number 2 by way of a letter to enable her to file a counter affidavit. Needful in that regard shall be done within 3 weeks. Rejoinder thereto, if any, within 2 weeks thereafter. List on 17th.
My lords, I appear for the state, my lords. Likewise, the same order, my lords, filing counter, my lords.
Respondent number 1 is it?
1, my lords. State of
counsel for respondent number 1 is also makes a similar request. May file this counter affidavit. Same here.
Great. My lord, there is a letter from the private respondent.
You don't have a letter
for adjournment.
For the letter?
No, Milords.
And it seems to have been communicated to him.
Milords,
Which respondent?
Milords, I'm instructed that the letter was not accepted by the registry. There was a letter circulated, but it was not accepted.
On what ground?
Milords, filing the counter affidavit. Milords,
Which respondent?
I'm for respondent number 2, Milords.
You need to file a count.
The state, I believe, also.
Yes, Milord.
needs-
Yes, Milord. So,
Milords, I just one small submission to make, Milords. On the last occasion, my lords had directed him to produce the Original sale deed of
Sale deed of
1965.
1965.
1690.
That is with us, my lord. That is with us. We can produce it right now.
So that we could incorporate our response in the counter affidavit,
Will you be,
if they are producing it.
will you furnish a copy to them?
No, it was to be produced before the.
Original, yes.
Yes,
We're
original.
not asking you to give the original to them.
No, copy.
Furnish a copy to them.
Just now we will give you.
Very.
Lordship in the
Sure. I do not remember now in what context I asked for the original.
There was an issue of forced sign, my lord. That's why.
How will we know?
Your lordship may.
That's what I was just coming to that next
My
submission
lord-
minutes, was that there is a civil title suit filed before the learned trial court. Till date, they have not produced this there. This actually requires adjudication in the title suit
Lord,
in
I
the
would-
trial court. They let them produce this there as well, so that the proceedings there can go on. Because of this one point that they have not produced this, in my learned friend would give me just 1 minute to make my submission. But if this,
A lot of stress was made on the last occasion, Lord. I just explained under what context your lordship had directed it to be produced. My lord, they were insisting that we do not have the original sale deed of 1965. And
That is the reason why.
yeah, that was the reason your lordship asked that, all right, in the end, your lordship will find, your lordship said that, all right, you produce it on the.
but falling from what my learned friend is saying, it's
Now I
been 2
recall,
years.
that was the statement, that
Yes.
you don't have the
It's
original.
been 2 years since the title suit has been filed. Till date, they have not produced this.
Well, now they produced it.
Now they produce it before this honorable court on the direction of this honorable court.
1565.
So let them file it there so that that suit can proceed as well.
Original sale deed dated 1965 is produced and perused. The same is returned to the learned counsel for the petitioners. Copies of the said sale deed may be furnished to the learned counsel for the respondent. Number two,
Yes,
you
I'm
also
just-
want it?
One, yes.
For
I'm just
respondent
giving
number one
copy,
and
you know.
counsel
In-
for respondent.
I'm just.
Counters may be filed by the said respondents within 3 weeks. They joined us there too, if any, maybe.
May I also seek this
thereafter,
indulgence?
List on 20th April.
Lord, may I
Earlier interim order dated 10/11/2025 shall continue to operate till the next.
I just one indulgence and let them place, the direction be given to them to place this, whatever it is.
You
in the
can,
title suit.
you can produce this before the trial
But
court.
this is not the original.
That's not the original.
This is the Xerox copy, madam.
The Xerox copy given to you.
And I do so.
We have mentioned that the original is produced, so you can
My
ask.
only concern is because what has happened is as late as December 25, there also, we found another buyer that is trying to sell off this property despite an injunction.
These are all submissions.
They have
which-
already made injunction application there and that.
File your account.
That will file our counsel.
A very peculiar kind of submission is being made.
Have given a particular.
They've given you a date.
I'm deeply obliged.
Public.
No counter in this. 58.
I'm for the state allowance, respondent number 2. We support the stance taken by the petitioner, but we seek time to file the counter.
Respond number 1.
I'm appearing on behalf of respondent number 1. We also see 2 weeks time.
Very well. Then counsel appearing for respond numbers 1 and 2 seek time to file their respective counter evidence. Usual order placed on safety.
Item 59.
That must apply.
Item 59, I am appearing for R1, 4 and 5.
No counter.
We are seeking time to file count.
1, 4 and 5.
Please, madam.
I beg to appear for respondent number 2. To put in a counter, the only thing was he was a.
You filed a counter.
We haven't filed it.
You also want to file, Mr. Agarwal?
Because we'll file, there's actually one document, my DIR 12, which shows I'm an independent non-executive director. And really, as far as I'm concerned, that's the basis of.
All the first 5
Counsel
are.
appearing for respondents 1, 4
I
and
am
5
1, 4 and
on
5.
the one hand, and the learned counsel appearing for respondent
As per
number
office
2.
report, R3 is
Seek
not
some
served.
time to file their
Services
counter affidavits.
for R.
That
As per the office report dated 16/1/2026, respondent number 3 still remains unserved. Steps shall be taken for completing service upon the said respondent.
But,
Rejoined us to the counter affidavits of, if filed within time, shall be filed. It may be filed within 2 weeks thereafter. List on. Dusty service was permitted last time also. Then this list you've given us, Mr. Sena, doesn't contain 10th April. 10th April is a miscellaneous day. It should be here. Not there. 14th is there, but 13th is also not there.
Tomorrow, I mean.
I'm okay.
Item 60.
No counter in this also. Counter. Who appears?
I have for the private respondent. The counter has been supplied, but it's not on record.
We've not filed it.
It's supplied to us.
Supplied to you,
Yes.
but not
Below.
supplied to you? No. So you've only kept it to yourself there.
Below.
We find that no counter affidavit has been filed till date. And counsel for the respondent shall do the needful in that regard within 3 weeks. Rejoinders thereto, if any, may be filed within 2 weeks thereafter. Earlier interim order dated 14/11/2025 shall continue to operate till the next hearing. List on 13th April.
Obligation. Item 61. May I request?
No counter.
So, my lords,
Counter is not there.
I understand, my lords. Will take 2 weeks to file the counter.
Very
For
good.
any reason, my lords, I'm only requesting.
You're for the state?
Yes, lordship. Lordship, the next date in trial court is 9th of February. That's why, my lords, I was looking to press for at least a stay or deferment
No.
to the trial court proceedings.
Cause is dismissed.
Yes, my lords, but my lords, we see the order issue notice where my lords noted the judgment of Mariam Fasihuddin and said that this is a case where a supplementary charge sheet has been filed without any further investigation. And the only change in circumstance was the fact that I had taken anticipatory bail. And therefore, my lords had pleased to issue notice in this matter.
What will happen in one hearing?
My lords, have already appeared, taken bail out. What may proceed with
Then
arguments?
counsel, you're appearing for the state?
Yes, lordship.
What about R2?
R2 serve, my lords.
No one's appearing?
No, my lords.
Lordship, they can take up this point in the trial court as well. They will charge.
R2, no one. Served. Let them file a counter, Mr. Luthra. Then counsel appearing for the state of Haryana seeks some time to file a counter affidavit. Then respond number 2 has not chosen to enter appearance despite service of notice. Counter affidavit of the state should be filed within 2 weeks. Rejoinder therefore, if any, may be filed within 2 weeks.
Lord, I don't have a stay because last time my lord said only notice.
So nothing will happen in one hearing. What
But give me a fixed date.
We'll give you a fixed date.
Until.
27th February.
Most obliged.
Item 62.
Lordship. Michael has not taken papers.
Yes, my lordship, I have been served with the copy. So
Why is it that you did not get in touch with the registry? The office report says that they were not able to contact you because you did not get in touch with them. We should have noted your mobile number in the order, perhaps, our mistake on the last day.
Apologies,
Now you've got the papers.
I have received the papers.
Did you get in touch with the
Yes, my lordship.
respondent?
The respondent is also appearing through VC
I see.
today itself. So she is willing to contest this matter. It was surprising to it came into my knowledge that it was the first time when I have served upon her the notice. She came to know about this initiation of this appeal. Prior to that, she did not have any sort of knowledge. However, the affidavit of service says something else.
Yes. Very well. You wish to file a counter then?
Yes, my lordship.
Very well. Learned Amicus Curie appointed to represent the respondents.
Who's also appearing
Seeks-
on it.
Is she there?
Yes.
Respondent seeks time to file a counter affidavit on her behalf. The respondent is also present online, though we don't see her. Though. She's there. Very well. Authentic information, it says whatever that is. So, needful in that regard shall be done within. How much time would you require?
4 weeks.
In 4 weeks. Rejoinder thereto, if any, will be filed within 2 weeks thereafter. List on 14th April.
Much obliged.
We still have the same issue. Why do you want a divorce at this ripe old age? You want to get remarried at 62, 64, whatever you are.
Lordship, it is irrevocably broken down.
But what do you want to do with this divorce decree? Hang it on a wall?
No, Lordship, this is because Lordship, they are property of the each party. So in case it is not that they may file the suit against each other.
Children must be there. No children?
There is
No children, Lordship. No children, Lordship. No. Date, please, Madam.
Given a date. 14th April.
much obliged.
No counter in this.
Lordships, I'm seeking just 1 week time to file a counter. We received the affidavit today.
Lordship, appearing on behalf of the petitioners, matter may be posted on 2nd February, Lordship.
Why? Auspicious day.
Lordship, instruction from the senior Lordship.
Very good. But you file your counter. Let the counter come. You can pick another lucky day after that.
Much obliged.
Then counsel for the respondent seeks some time to file a counter affidavit. Which will list on 10th March.
Item 64.
10th March would be too less, maybe. 6 April.
64 was to be taken up on a non-miscellaneous day.
Yes.
Here, my lord, 34 order is reversed in my favor, in my appeal in 37.
Very.
And the termination is upheld.
Take it up on
Malads, may give us a date, Malads.
Yes.
Any Friday, Malads, in February, Malads, if that's possible.
Non-miscellaneous days. You join the queue.
No, Malads have been posting it on miscellaneous days, Malads. Malads, we'll see the last few dates, Malads.
When is the next available miscellaneous date hearing? Give it a little later so that this kind of cluttering, if it's there, then there's no point.
My lords, I think it has to be heard. It's to be on a non-miscellaneous day. Anyway, so I leave it to my lords.
Miscellaneous day, provided I don't run riot with the listing and we don't end up with 95 matters, you might have a chance in the afternoon, Mr. Patil.
Very well. Very well.
Well, that chances appear to be very rare. Your lordships will be flooded with matters.
We'll take our chances, Malads.
There was a disaster because solely my responsibility, but hopefully
No, my lord, every court faces this problem, my lord. It is. But scattering, my lord, is the solution.
9th February. No matters listed for hearing on this. 9th February.
Grateful.
9th February, with the understanding it will be taken up after the hearing of the other matters listed on that day is complete.
Very well, Malads. Grateful.
Please.
Grateful, Malads.
Obliged.
Letter, help me, sir. Letter, Lordship.
We don't have a letter. In the 2023 order, there was no stay. The First Appellate Court has not proceeded with the matter.
Lordship, list any date, my lord.
No. To answer the question, no stay was granted here. Matter was remanded to the First Appellate Court to hear the appeal on merits and dispose it off. Has that happened or has it not happened?
Actually,
you don't know what the case is.
Not
You don't know.
Counsel,
How many? You also have 95 matters today?
No, I have no.
We have 95 matters. I bother to read your file. You don't bother.
Oh, I'm sorry.
You are appearing for.
The respondent, my lord.
What, do you have any idea whether the First Appellate Court has taken up the matter?
My lord,
You also don't know.
I.
You also have 95 matters. Very good.
Obliged.
Counsel for the parties seek an adjournment. They shall ascertain as to whether the First Appellate Court has proceeded to hear the matter, as there was no stay granted in this special leave petition. List on. Now I think we can go to May also. So 4th May.
Very short matter, Lord. In fact, the SLP is itself not maintainable. One of them is against a conceded order. Another one is not after us. Taking all the OTS money covered by a judgment of this court.
One. council.
This is quietly covered.
66.
Yes.
There is some problem in
Some-
this device.
Who's appearing?
Who's appearing his name? Shyam.
Sham Gopal. He's there online.
But there is some problem.
So now you've deposited this 95 lakhs.
Long ago, it has now become 1 crore 30 lakhs already, my lord. In fact, after accepting not over and above the OTS money, they deliberately cancelled the OTS. I find that
Your initial outstanding must have been much more than 20 crores
22 crores, not I have actually deposited 22 crores as per the OTS.
at your convenience.
Yes.
At your convenience, you've deposited.
Sorry.
You did not deposit it within the time frame.
No, I have a table.
You were supposed to deposit the 20
Right.
crore amount.
31st of March 22
Yes.
and with interest 31st of March 23.
Whereas you paid only 13.10 crores by 31st of March.
By the 3rd of June 22, I paid the entirety. Why? Because if
Once you fail to stick by the timelines, the OTS is to begin with a haircut for the bank.
yes, I need.
And then they're taking lesser amount with the hope that you will at least cough up whatever you are willing to cough up
Let me clarify.
within
what
that time frame. And you don't do that. And then you say, no, the OTS amount is binding. on
Sorry,
you.
let me just tell your lordship what had happened. Let us clear this misunderstanding. One is that, Lord, the understanding
He's
was.
not able to join.
Logged in, my lord, he's not.
He's not able to
unable
join.
to unmute.
No, but one thing we didn't understand.
No, I don't know.
I see, he just told me,
just-
you're not there.
No.
You're not there, Mr.
I don't know what.
Actually, my lord, the understanding was as and when the amounts are cleared,
Anyhow,
the
he's
document
not
of
there, so
respondents were to be released, which they didn't do. Yes, which they didn't do as per the understanding. But my lord, all said and done, amount is already there.
Petitioner has joined online but is unable to address argument.
And we need a short date because the others, my properties.
You've already got the stay of the contempt proceedings, don't you?
No, they got. They were to release the document. They had to release the
have
document. My property is blocked, my lord, and I can't do anything with that despite all these monies having been paid. Kindly give a very short date.
By the respondent. One
Sorry?
of the respondents, I believe, has circulated the letter. So,
We don't
No.
know.
yes.
Last time I mentioned and got it listed, my lord, in fact. Our side got it mentioned and listed it.
We'll see.
We never circulated any letter for this.
The list on
Very,
16th March.
good. Sometimes in February at least.
Can't be.
Good. Second week of February at least. It's a very, very short issue. Amounts, everything has been paid and over above also is deposited. Now, my lord, only the suit is there. He's
20th February.
very well.
Earlier interim order.
It's a Friday.
Earlier interim order shall continue to operate till the next year.
Lord, can I just pray one thing? Lord, may I make a prayer, my lord? Admittedly, all monies are received, my lord, and out of 3 respondents, 2 respondents' document have been released also. It is only one property which is the most valuable, which they are refusing to release, my lord, which is what we filed the contempt for. 2 courts have held.
You'll have to hear them.
Lord, kindly release it subject to the outcome,
begin
Lord,
with,
and
we
my
don't
money is already
understand-
there.
Madam,
We don't
please stop
understand
him
why
here.
they have scaled down the amount in the OA. Because
90
once
lakhs.
you-
90 lakhs.
Exactly.
OA.
And they need to explain as to why it's been scaled down to 90 lakhs. Because once the OTS fails, then the entire amount becomes liable.
No, it was
If
not
it-
failed because they did not oblige as per the OTS agreement, my lord.
That is again something that is debatable, is it not? According to you,
It's there on record. It's there on record, Lord. I placed it on record.
this
5 crore
OTS
is one
itself is
property.
rather peculiar because I've never come across such an OTS.
Lordship
that
will see, I'm.
will make one payment,
And then
one
it-
document will be released.
Yes,
You
yes,
understand?
that was the OTS, Lord. That was the understanding.
And
because
was it also mentioned that after the release of that document,
Yes.
you'll sell that property and then make the next payment?
It's not only after the
Did it
release.
say that?
Therefore, yes, my lord.
That after the release of the document, you'll sell that property and then make the next
That
payment?
was up to us to sell it and or mortgage it
Therefore,
in
you
a
have-
bank or give it to them.
Therefore, your liability to make the payment was independent.
No,
There's
subject to the
question
release.
of your
Subject
saying,
to the release of the document.
there's
Subject
no
to
question of your saying that I did not pay because they didn't release the document, I couldn't sell.
Yes, my lord. That was the understanding
Let
in
us-
the OTS proposal.
Let us see, let the other side continue.
Very well.
Let's see whether you. 67.
Leonard SG is appearing to be basic.
No, 67. Lord,
Comes
the
for
other
the
side,
petitioner from there.
Lord, landowners, my lord, sought benefit of Tarsem Singh judgment
Petitioner's counsel is missing, so we'll have to give you a date, Mr. Solicitor.
Yes, my lord, Tarsem Singh's judgment is under review. The review is
Tarsem
heard
Singh.
in open court and notice is issued by the honorable bench. So
Nice.
your lordships may consider having it after 5 weeks, my lord.
Very well. No representation for the petitioner. Then Solicitor General states that the review filed in relation to the judgment of this court in Tarsem Singh. Just trying to fill
The same thing is the 3-year. Why should we review?
Now been entertained. So,
My lord, I'm sorry, my lord, I was mistaken. The review was dismissed. Thereafter, I moved clarification, which is entertained
review
and notice is issued.
dismissed, but the clarification petition filed in relation thereto has been entertained.
And notice is issued.
List on 11th May.
Please, sir.
Item 68.
May it please, Your Lordship.
Yes.
Lordships, I appear for the respondent.
No counter affidavit.
We'll file it, Your Lordship. There are certain documents, also some reports which we need to bring.
And counsel appearing for the respondent seeks time to file. Respond number 1.
Please, my lord, there's only
Respond
one.
number 1. And others it says.
Others, my lord, I'll just, the other insurance,
Respond
other
number
offices,
one.
my lord. It's the same company.
Seeks time to file a counter affidavit along with supporting documents.
Please, my lord, the
Which
document.
form the part of the record.
Some
Which
reports.
form part of the record before the NCDRs. Visual order. List on 18th May.
Wait for
Item 69.
Your Lordship.
Service is incomplete. You're appearing for?
Respondent number 1, Your Lordship.
1. Who's
The
for the
counsel
petitioner?
is, sir, the arguing counsel is in some personal difficulty. So
Sorry?
the arguing counsel is in some personal difficulty, so I request a short.
In any event, service is incomplete, but he's filed an application for deletion. Have you received a copy for? You are respond number 1, is it?
Yes, yes.
They are asking for deletion of the names of 2, 3, 4, 5, 6, and 8.
Yes, Your Lordship.
You have anything to say in the matter?
Your Lordship, the arguing counsel will be.
Adjournment is sought by the learning council. Hearing for respond number 1 on the ground that the learned arguing council is indisposed. List on 4th May.
Item 70.
Item 70,
No counter.
I need some more time because a policy decision has to be taken, my lords. Because so far as the government servants are concerned, my lords, the policy decision has already been taken, but the.
No, but in terms of the judgment,
He's a daily wager, my lord, not covered, and he's not a government servant.
You're not a government.
No, he's a daily wager, if I can.
Yes.
He's
But
a-
you made them permanent employees.
Yes,
after
no,
10 years.
clarification by this honorable court that the word permanent is not to be construed as a regular service, my lords. There's a clarification, my lords.
What do you mean by making permanent then?
Because these daily wages, they are governed by a resolution of 17/10/1988.
No, but do you have a separate status of permanent employees?
Not
as
permanent.
opposed
The
to Regular employees?
the term permanent does not.
Retire, you give them a retirement notice and a retirement order.
And
they're getting pension as well.
Pension also is.
Yes, Your Lord.
Service conditions are governed by a resolution, separate resolution.
No, but you've come up
Not
with a
a-
new service jurisprudence concept, is it?
Malas, I'll-
Neither regular nor daily wage, but permanent.
Malas, they are.
Very well. What is it that you want to file a counter?
I'll-
Then counsel for the state of Gujarat seeks some more time to file a counter activity. Needful in that regard shall be usual order. List on.
Your Lordship, may I mention only two aspects, Your Lordship. In the same issue, the Honorable High Court directed them to file reply with regard to two judgment of this Honorable Court, where say that the 1988 circular made regular means they are permanent employee. You give reply to, they haven't filed reply in High Court as well. There are two judgments.
Let them.
It's an order of this court, my
Let them.
lord.
Yes,
file a
that's
reply here. It's the 17th day.
Indeed.
Item 71.
Service
My lord.
incomplete. Service is
71 and.
incomplete.
Yes.
Lord, seeking 4 weeks time for filing
Your
counter
for which
affidavit for
respondent?
R6, my lord.
R6.
New India Assurance.
Service is incomplete as per the office report, so please look it up and whoever needs to be served, takes steps. Office report dated 16/1/2026 furnishes the details of the respondents in this batch of cases who remain unserved as on date. Necessary steps in that regard shall be taken by the learned counsel for the petitioners. Learned counsel for
For R6, respondent number 6, my lord.
respondent number
I am
In 4
appearing
weeks.
for respondent number 2 in 71. In 71.1, I have filed counter. 71, I need to file counter.
respondent number
2 in 71.
respondent number 2 in SLP in item 71. And you
Respondent number 6, my
in
lord.
71?
Yes, ma'am.
In 71, seek time to file the account. Usual order.
Great.
Based on 14.
Item 72.
71.1 is also there, my lord.
Yeah. 71.1 will go with that.
There, my lord, I am respondent number 9, my lord.
You need to file account. Respond number 9.
In 71.1, my lord. Grateful.
72.
In 72.
Some application you filed for deletion and the other side wants to oppose
Counter has
that.
been filed.
Counter is filed now.
And last occasion, they took time for arguments on deletion petition, Miller.
The deletion is, my lords, of my co-plaintiffs who are respondents.
We'll pass it over. In the event we have time in the afternoon, we can take it. Matinee show today.
Some difficulty in my, my lords.
Very good. How long do you propose to take?
Lordship may,
If you finish by lunchtime, both of you, then.
there's a 12 to 3 show also and 3 to 6 both are a little difficulty today to argue, my lords. If your lordships may accommodate me, otherwise, my lords,
Very good.
yes.
Some other day.
SLP itself can be held, my lord.
Well, matter can be disposed of, Miller. The simple questions are involved, only question of law, Miller. Other
Today we are a little hard pressed, but afternoon we could have accommodated because I didn't expect to get to item 72 by
Because even the
lunchtime.
bar didn't expect me.
all fields are completed, Miller. But please, short questions are involved.
Where are you off to, Mr. Dave?
No, I have 2 matters.
You have 2 matters passed.
Not off, that luxury is not there.
That luxury is not.
Any Monday afternoon, your lordships may fix it, I'll argue it, my lords. You want it, argue? Well, then lordships may fix it today only, my learned friend will argue, I may not be there.
Very good. Then we'll pass it.
Obliging.
Item 73.
May I please, your lordship? Your lordship, on the last occasion,
Issue notices to Devistan department.
no one enters appear in this matter, my lords. The service is complete, my lords.
No, my lord. My lord, Devistan department is not appearing, my lord.
My lord, the service is complete,
But no one is appearing.
my lords.
That is the usual course of affairs in this court. It is not states do not choose to come.
My lord, may I say this?
Is there a designated standing counsel for the state?
Yes.
Your Lordship, I am appearing for the state. We seek 4 weeks time to file.
Why are you keeping quiet then? Waiting for the focus to turn upon you. Till then you thought you might get away without having to open your mouth.
Apologies.
Learned counsel appearing for respond number 8 from the state of Rajasthan. 6 time to file a counter affidavit.
With regard to the status of temple, my lords.
My lord, any
Counter affidavit with regard to the status, counter affidavit with emphasis upon the status of the subject temple.
My lords, I'm so grateful.
Based on usual order after that, then 20th month.
My lords, I'm so grateful.
Item 74.
74, justice service is there and no one appears. Union of India. Union of India, no one appears. Come for the petitioner. No representation for the petition. Is there? Is there? What is that? Everyone is having a problem. Our side problem is it? We are having a problem. We are informed that the General Counsel for the petitioner has joined online but is unable to appear due to a glitch in the system. We find that the Union of India has not chosen to enter appearance before this court despite service of notice. Learned Counsel for the petitioner is permitted to effect service upon the central registry to ensure that there is representation for the Union of India at least on the next date. List on 13th.
Item 75.
Safety.
Your Lordship,
No counter.
requesting, yes, I'm requesting for some time to file it.
You're for which respondent?
All the respondents.
All of them?
All of them.
And counsel appearing for the respondent seeks time to file a counter affidavit, needful in the usual order. Is that foreign exchange issue?
Yes.
Eighth April.
Very grateful. Very grateful.
Item 76.
I am appearing for respond number 1 minutes. I filed my
No counter.
Lords may give me 3 weeks minutes. I'll put my counter minutes.
One counsel appearing for respondent number 1. File a counter. What about the other respondents? Are they served? There's only one more.
There's one more respondent.
It's a performer respondent.
No minutes.
Performer. Served any.
Let me say performer.
Respondent number 2 has not chosen to enter appearance despite service of notice.
The respondent number 2 would have a critical role minutes. In fact, High Court
If he doesn't choose to come,
specifically directed them to impede respondent number 2, in fact, in section 11 stage.
Counter affidavit, respondent number 1. Usual order, list on 10th April.
Obliged. Obliged.
77.
No, the lecture paper, the petition, the present
I'm
matter.
appearing for
Counter.
respondent number 1, Lord. I'm trying to 4 weeks to file it out.
Lead counsel for respondent number 1. You also want time? Then counsel for respondent number 1 and then counsel appearing for respondent numbers 2 and 3. Seek time to file their counter affidavits. Usual order after that.
Whereas we also counsel stand to file a rejoinder. if necessary.
Joined also. 6th April.
Item 78.
The respondents have been served.
No counter. Someone is appearing also.
My lords, I appear for respondent number 2 and 4, State Bank of India and Indian Bank. I'm seeking time to file my reply, my lords.
2, 3, 4 other banks.
State Bank of India is there.
Yes, my lords, I appear for the State Bank of India.
Financial implications
Yes.
are there?
My lords, it's a case
Yes,
of
my
a
lords.
personal guarantee.
No.
Financial-
State Bank of India
Is a
stands
consortium.
to gain financially.
Yes, consortium.
This before a bench in which one of us, I don't not remember.
Please give us time to.
Grateful, my
file
lords.
We are listing it before a different bench, so you.
Obliged.
Grateful.
Item 79.
Lord, 79 to 83 are after notice matters. Lord, I'm
Madhya Pradesh.
praying for some time to file counter affidavit.
Very. And council appearing for the state.
I'm for
Also for the
State and
the corporation, the mining corporation.
joint council appearing for the respondents. Seek time to file their respective counter affidavits. Needful in that regard, within.
The interim order can be extended.
17th April. Earlier interim orders shall stand extended till the next hearing.
They can
Up to
all,
83.
they can be tagged together. man.
Tag them.
79 to 83 may be
Why they are
tagged.
not?
Yes. Great.
Tag all these matters together. Up to item 80.
And one matter, there's
79
no
to
interim order.
83.
One
79,
matter, there's no interim order.
There's no.
One of my matters.
Earlier interim orders,
Yes.
if any, shall continue to operate till the next year.
Great.
Wherever they're there, they'll continue.
Yes. Lordship.
item 84.
'84. Yeah, 84, IA number 316492 of 2025. The delay in the filing of spare copies is unknown. The registry may take steps for effecting service of notice upon the respondent list. 13th April.
Very good.
Item number 85.
Your Lordship,
Counter is filed.
counter was served on Saturday.
Yesterday.
Yes, yes, Lordship. And seeking some time to file the report.
And counsel for the petitioners seeks time. Petitioners seeks time to file. There's only one petition. Petitioners seeks time to file a rejoinder to the counter affidavit. Filed by R1, is it?
Yes.
Counter is by R1 or R1?
R1.
Counter affidavit of R1. What about R2?
The distributor minutes.
So no counter will be. Anyone appearing for R2?
No, not even for the height.
Yes.
That's the difference.
Joined it. Right. Same date. April.
Item number 86 along with 89.
Princeton University.
Princeton University.
Your Lordship, requesting for a short passover. We're led by Senior Advocate Rama Sheshadri Naidu sir in this.
6 and 8. Very possible.
But there's an intermodal involved.
Not complete in any event, 86 and 89.
No, they have not filed a counter.
Then what is the point of it then?
Your
You
Lordship,
already granted an order in 86.
Your Lordship, we filed an application for vacation of that order.
You need to file a rejoinder to them?
No, we have.
You filed it.
They filed now.
So you need to file a rejoinder.
We'll file a reply.
So you have not filed a rejoinder.
No, it's coming up. We served just yesterday.
No. So you
Okay,
need,
Friday,
you
Friday.
need time to file.
Yes,
it.
yes,
Then
please.
why don't you say so?
To file a reply, yes.
So that's in 86, is it?
86 and 89.
No, 89 is the other one. What is-
89, we are for the petitioners.
You are for the petition.
You filed an appeal.
Yes, sir.
On the last occasion, Mr. Parmeshwar appeared.
Yes, Your Lordship.
So this time you've got Mr. Seshadri Naidu. So trying your luck, is it?
No.
Neither is my favorite. So whatever ploys you are adopting, let me disillusion you right away.
Your Lordship, answer is.
That Mr. Seshadri Naidu, you're not my favorite counselor.
Give him the context quickly, Ullah, because it's already out of
the
there.
back. But anyhow, let the other side file a rejoinder.
No, probably they thought that both of us.
You can also say it.
Not his favorite, it's not my lord's favorite.
Very well. Learned counsel for the petitioner. Miss SL 86, 6 time to file a rejoinder to the vacate stay application filed for the other side. Based on, along with that other item.
89, if they can give us a copy, the notice has not been issued.
Oh, notice has not been issued, it's just been tagged, I think.
Yes.
So you furnish him a copy. Furnish him a copy of.
We will immediately.
List on
Interim order to come.
6th April.
It took a while.
But interim order.
My last posted to.
6th April.
Great, sir.
87.
My lords, I have here for respondent 1, 2, 4 to 6. This comes first time after notice, my lords.
Counsel,
4 weeks time.
you are appearing for 1,
1, 2, 4 to 6.
1, 2,
4, 5 and 6.
only 3 you are leaving out.
Yes.
What's he done?
Refused.
My lords, I.
And my instructions are to.
Very well. Learned counsel appearing
Those
for
3 and 7 refuse service.
3 and 7 refuse, so they deal, sir.
They are the brothers.
That's learned counsel appearing for respondents 1, 2 and 4 to 6. Seek time to file their counter affidavits. The respondent 3 and 7 are deemed to be served. We don't have the office report here. There is an office.
Millets, it's been served from the court. When we tried to, that's they refused. So in effect, they've been served.
But have not chosen to enter appearance before this court. The usual one, counter and rejoinder. Based on.
Break.
Based on 13th April.
13th.
Item 88.
Lord, some short Passover.
Lord, instead of Passover, please have it done.
Really intended that all the cases should
Be heard together.
Nothing it
That's the request.
Otherwise, it doesn't make any
Any
sense.
sense.
That sentence doesn't make any sense.
And you have been
Those
doing-
writ petitions need to be.
And you have been filing multiple litigations without, what do you call,
without using-
amending the earlier writ petition.
This matter is being.
Which is maintainable also. It's not
The matter is being led by the senior counsel.
That doesn't make any difference.
But you are asking for a, what did you say?
They wanted separate.
Clarification.
Clarification. No clarification.
Lords, may I request Lords may have it on Monday.
Modification, you said.
Lords,
Can't be a
Lords, the request is Lords may have it on Monday. Lords, we are being led by Mr. Patwali.
Very well. Come in.
Lords, the learned senior counsel is.
Come in the afternoon.
I think Patwali has some difficulty, then your lordship may take it on Tuesday, there is no problem. Accommodate. Monday is a holiday.
Next Tuesday.
No,
Tomorrow.
Monday, tomorrow is fine. Tomorrow is
125 items.
so therefore Tuesday.
I'm outdoing myself each day.
Lord, very nice to see that 88 reached a sharp 1. Lord.
NMD.
That's really something.
Only.
Because of the Skara conference, so Tuesday.
We are not doing.
Then Lord, tomorrow morning.
Next Tuesday.
Lordship.
You are not going, I suppose.
But the physical appearance may be.
My Lord's
Not physical appearance.
My Lord's kind permission, Lords,
Yes,
may I seek my
Obliged.
Lord's indulgence for item number 3. Lords, I got stuck in pardoning, my Lord's
What happened to
date. My Lord have given a date for 26th of February, 27th of February. May I only request,
Ms. Gupta, the respondents, the minors are shown as represented by their dead father. So that also is a
will
mistake. there.
correct the
You need to take steps for amendment of the.
Can I just request for a shorter date in place of Lord's February 27th, somewhere Lord's last week of January, if my Lord's board permits.
About a month from today.
It's the blink of an eye.
More than a month, my Lords, there is a gift deed in favor of them, my Lords, the only thing is, any convenient gift.
According to what the High Court said, you need to go before the revenue court in the first instance.
There are-
Start that process.
Lords, I'll cite section 242 of the Tenancy Act. There is a contrary view by the coordinate benches.
Let it come up.
My Lords, any shorter date, my Lords,
Passed over.
any shorter date, my Lord.
Very good.
My lords, in item 50, the exemption.
20th February. When you're getting a week ahead, be happy with.
Kindly consider to give me somewhere in first week of February, my
16th
Lord.
February.
My Lord,
In item 50, the exemption from surrendering had to be extended.
We've granted extensions wherever.
My lords, it wasn't recorded.
50 exemption from surrender, not there? Second, let me see the.
Please add it.
50, I said exemption from surrender. Not there?
Will issue notice on the proposed.
Probably you might not have said it at that
Issue
time.
notice on there?
50.
50.
Notice was issued on the IAP, but the exemption from surrender was not extended.
Exemption.
I mentioned item 72, my lords, passed over matters. Even both respondents are in some difficulty, my lords.
What difficulty is there?
My lords, the senior advocate, my lords, have some difficulty.
What? You have to tell us what the difficulty is.
My lord, they are engaged elsewhere, my lords.
Right.
My lords,
He
can
wants to
please
go to
have-
Lodi Garden for a walk. Then
Please, my lords, only for today, my lords, it can be had.
Lordship,
Even the petitioner also requested for the.
you come back at 2 o'clock.
Much.